Changing the operating of that changing. See, our next police academy, who's like, I think about it. Adam.
Right.
Hey, I'm always on people's door. That. PTSD.
So Deputy Gordon is flying solo again this morning. He's bringing people up, but we can get started if we've got anything that involves people not in custody.
Judge, I can't see the Zoom, but there might be a person from DOC with us. And I'd be happy to head it.
Oh, Mr. Essic, yeah. We don't yet, but let's find out if Ms. Nelson has lined that up.
Yes, Judge, he's lined up to attend today.
Okay, so they'll pop on once they're able, the GDC people. Did they give us an expected time?
I believe it's 9 o'clock, Judge. I'll reach out to them. They had a couple on their schedule for today.
Okay, all right, thanks.
Yeah, this one is already out on this, so we should be able to take care of that.
While we're waiting, Ms. Simpson, how much time remains for Eugene Alexander? It's number 6.
He has 6 years, 3 months, 4 days.
Right? And Christopher Clark, number 7.
That case is expired.
Expired. That's another one. Okay. And then Davion Hayes.
He has 2 years, 1 month, 3 days.
All right.
Did you get the time for me?
Yes. Yeah, and apparently he has a second case. What I don't have is any warrants on him. So Ms. Nelson is looking for those. She didn't attach them where she stashes all this stuff. Hey there. How are we? Sorry, Deputy Gordon, I let folks in. I know you weren't here to give, Deputy Gordon's doing his exact job for security reasons. People don't sit on the first row. You didn't do anything wrong. You came in, there was an empty room. No one's upset. We're just gonna get people situated consistent with how we always do stuff. I opened the door because I didn't want you stuck out in the hallway. You bet. I got it. Well, at least I got the 13 SC one. I'm assuming the 24 SC is the same.
Yes, it's way worse the same.
Okay, it's a new offense of forgery.
Yes, but the petition, which
not.
I believe the 24 is the one is the.
Oh, okay, then I guess I should get a copy of that if you want to send it my way.
I know, right? I know. Let's figure this out.
All right, let's see if that prints out. Oh, he stepped away. You ready?
Yeah.
Okay. Yeah, it was odd. There were only a few things that were attached, but prosecutors, oh, that's 8C. Yikes. Hi, everyone. Let's get rid of that. Awkward. Don't report. 8C prosecutor is gone. We had jury selection from next door playing in here this week. Yeah, it happened twice. They grabbed our monitor. Let me, it's a shoestring budget today. 8D prosecutor. There it is.
Oh, okay.
Mr. Hassan's thing. All right. So let's get started. We had a single position motions calendar involving Mr. Bruce, but I don't know that Mr. Bruce is here and he needs to be. So I guess that'll affect his bond conditions, but.
Yeah, but I imagine he's on his way, Judge. The traffic was a little odd this morning trying to get here. Several of the lanes are narrowed down to one. So.
No, every lane is narrowed down to one around the courthouse. So you believe Mr. Bruce is on his way?
I do, Your Honor. If you would permit me to, I'll step out and join.
Definitely. And you are?
Katie Ingram here on behalf of Mr. Al this morning.
Great. All right.
Mr. Bucking? Yeah. Okay.
Yep. So if you give us an update on Mr. Bruce, we'll table that for now. Okay, then let's turn to our inquiry calendar. Position 1 is Abdul Hassan. Oh, sorry, deputy's on the phone. Who's handling Mr. Hassan for the defense?
I am, Your Honor. This is Jenny Hurwitz with Georgia Justice Project.
Hey, Ms. Hurwitz, how are you?
Hey, I'm doing well. How are you, Judge?
All right, Hurwitz. All right, let me make sure he's here. And then have you spoken, Ms. Hurwitz, with Ms. Dilligard about Mr. Hassan's 2 revocations?
I have not, Your Honor. I am representing him on his new felony matter, which I believe is on before you at the end of May.
Okay.
And so in light of that, I was wondering if it would be possible to reset, because we are in the process of trying to work out his admittance to accountability court on that case. But we have just started the referral process. So we do have a little ways to go in terms of figuring out that case and the outcome of that case. But I was just yeah, hoping that we would be able to reset, to see what happened with his new felony.
Got it. I bet we can do that. I'll get input from the prosecutor in a second. I'm looking at a petition. That's why I didn't get, this is a Judge Whitaker case, which is why we didn't, yeah, that's all good. The petition for Mr. Hassan's more recent case is different from the warrant that I signed in the older case in terms of the basis for the revocation. There is the situation from Lexington, South Carolina, and then a much more recent alleged burglary, and then also theft by deception, and then more second degree lots of second degree lots and lots of. You have all those? It's like 8 or 9 second degree burglaries.
Yes, I know. Yes.
Okay. And they've been indicted, and somehow I got that case.
I believe only one has been indicted, Your Honor. I believe there are a number, the vast majority are still unindicted.
Got it. But your hope is to come up with a global resolution that would result in Mr. Hassan maybe pleading guilty to some things. Some are diverted through pre-indictment diversion into one of the accountability courts.
That is correct, Your Honor.
Okay, but that will take time, in particular, given the number of alleged second-degree burglaries. And so you're asking to kick this down the road a little bit.
I am, yes.
Do you have the indictment number for the case that's happening when you say later this month, actually today is the last day of the month, so it'd be later in May?
I'm sorry, yes, at the end of May, and
Okay.
I do that, that.
Oh, I have it. I'm sorry, I just found it. It's right here. So let me look that up. And while I'm doing that, Ms. Dilligard, do you have any objection? You have sort of a confused look on your face as we've been talking about this.
No, I have no objection. I couldn't, for the revocation, I was prepared to ask for some custody time. And so she's talking about accountability court, but I'm happy to speak with her offline. I don't have any objection to presenting it.
Okay. I want to be clear. I'm not committing one way or the other. It may well be, given all those second degree burglaries, that there is timeout before an accountability court situation. But it sounds like you and Ms. Hurwitz having time to discuss and looking at it seems like a pretty broad landscape for Mr. Hassan. Figure out what makes the most sense. Let me just pull up the newest case.
Mr. Bruce.
As in person?
Yes, in person. He's
Okay.
coming in now.
Okay.
And I spoke to Adam Hoover, but I'll let him, or Mr. Fox, I'll let him speak for himself when he comes back. And I believe he's also in college.
Okay. We'll get to that in a sec.
You moved on, the judge. I was 5 looking for you.
That was long ago.
I was stuck in one seat for years, and so they didn't let me out of there to try anything else.
Okay, so Ms. Hurwitz, yes, he is listed as Mr. Abdul in the new case. I think they probably got his name flipped around. And you are listed as his attorney, and we have final plea on May 29th for the 25 SC case, which has 2 of the various second degree burglaries and 1 possession of tools for a crime. So you're not objecting, Ms. Dilligard, if we just, hey, Ms. Charles, if we just move this revocation to join in with the final plea on the 29th?
No objection to that.
Okay. All right. Deputy Gordon, are we able to do what we did yesterday where we could bring someone to the door? You got a real deputy. All right.
Good morning.
Good morning. Where'd they have to bring you in from?
The 9th floor in the middle of work.
Yikes.
All right, how are you for me?
I'm happier now that you're here. Actually, I have to go up to the 9th floor at 11:30 today, so maybe you can help me get in.
Abdul.
Yes, well, yeah, it's Abdul or Hassan. Same person. Ms. Hurwitz, I'm gonna put you on the screen because now that we have 2 deputies, he can come right on out.
Great.
Good morning, sir. If you come right up to the podium there. Good morning.
Good morning, Mr. President.
Do I call you Mr. Hassan or Mr. Abdul? You are in the system as both, and I'd like to be calling you by the correct name.
Hassan.
Mr. Hassan. You've been a busy guy. You have a whole bunch of cases.
Yes, sir.
You got a real old case, which is why you're here today. It's also a burglary in the second degree, but it's from 2013. And I signed a probation warrant for you because of something that happened in South Carolina, probation in connection with your case from 2013, before my time.
Right.
But the judge who had that case, I inherited her docket.
Yes, sir.
But it turns out that in the meantime, one of your more recent sets of second degree burglaries has been indicted, and coincidentally, it's assigned to me. Ms. Hurwitz, you can see on the screen there, your lawyer from the Georgia Justice Project,
Yes, sir.
has asked that we hold off on this revocation. You're due back here in late May anyway for what we call final plea, which is sort of the last day to work your case out, where you could withdraw your plea if you don't like your sentence on that newer case. And so Ms. Hurwitz is going to try to do several things. One, see if she can negotiate with the prosecutor who's seated behind you about a global resolution. Two, you've got a bunch of unindicted second degree burglaries. She's going to see if she can wrap those into this resolution so you don't keep getting pulled back into a different courtroom on what sounds like a related situation, whatever's going on in your life.
Right.
And then three, handle the revocation at the same time.
Yes, sir.
You have two open probation cases in Fulton. The real old one from 2013, which I've inherited, and then a much more recent one from last year in front of Judge Whitaker. And you got a chunk of time left on both those.
Right.
The goal would be to handle everything at once so that one judge is hearing why to do whatever the state says, and maybe do some time and then get you help, or do what Ms. Hurwitz argues for, which might be to get you into some form of treatment. I'm just letting you know what we're doing. We're deferring all this till that late May date. And by then, Ms. Hurwitz hopes to have lined up whatever she can line up.
Okay.
And we'll talk about everything, revocations and that new indictment on that date.
Okay.
Do you have any questions?
Yes, sir. The probation for Judge Whitaker. I've written her and asked her if she could transfer that to this courtroom so we can handle all that. I didn't get a reply back for that yet.
So when you say you wrote her, like you wrote a letter to the Judge Whitaker?
Yes, sir.
Okay.
I explained it.
She's probably not going to write you back, but that doesn't mean she ignored your letter. I will take care of that. My team will reach out to hers to say, do you mind if we manage the 24 indictment? It makes sense to have it all under one roof.
Right.
She and I cooperate well, so I can't think of any reason why she'd say no unless you really, really upset her at some point.
No.
And my guess is, and I don't mean this in the wrong way, she probably don't even remember your case.
Okay.
And so that means she'll say, sure, you can take it off my plate and put it on your plate.
Okay.
So we'll do that. Other questions?
Yes, sir. The other thing was that the social worker came to me at the jail.
Ms. Patterson?
No, it was Mr. Stansberry.
Okay.
He's the social worker from Judge Whitaker courtroom. And he asked me if I would be interested in going to accountability court. So he was supposed to send these accountability court interview referral over there to me at the jail. This was like last month.
Okay, well, let's hear from Ms. Hurwitz, because judges don't have social workers, unfortunately. I wish we did. That's not part of our team. Ms. Hurwitz, is that a name you recognize?
It's not,
I have
Mr.
his
Hassan, we have initiated the referral process for accountability court, and
Okay.
it can take some time because sometimes they have to get records and other things before they go out and sort of and interview you, but that should be coming soon.
Okay, gotcha.
Yeah, and Ms. Hurwitz, I can help with that if you find that the intake team, it actually shouldn't take a ton of time. We are always open to growing the census. So if you're not getting 3 or 4 day turnaround, let me know and I'll bug the intake team. Mr. Hassan is easy for them to find. It's not one where they need to go out in the field. They'll be going straight to Rice Street, and Hope Hall is literally next door. When did you initiate the intake process?
It's my understanding that Jackie reached out to them last week, but she's out sick today, so I can't verify exactly what happened. But I will circle back with her as soon as she's back in the office just to make sure that the ball is rolling.
Got it. Okay. So that's part of what Ms. Hurwitz is trying to do.
Okay.
Now, I need to let you know, just because you get accepted into accountability court, that doesn't mean that's the immediate outcome.
Right.
There may be compelling reasons that the prosecutor says, maybe in 6 months or 9 months, but Mr. Hassan's going to need to have some consequences for all the things that supposedly happened in November of last year. So I want you to be hopeful. I'm a big fan of accountability courts. I'm one of the judges there.
Okay.
But there may be a 2-step process for you where there's a revocation followed by your admission into accountability courts. And that's assuming they accept you. Looking at what kinds of things you get in trouble for, you seem like a good fit. You're not out there putting a gun to anyone's head. I think that Ms. Hurwitz, as usual, is onto a real good plan of rehabilitation and support for you.
Okay.
Any other questions?
Oh, that's about it, sir.
Okay. Ms. Dilligard, anything else from the state?
Nothing really, guys. Thank you.
Then I will see you and Ms. Hurwitz at the latest at the end of May for the final plea. If you guys sort something out earlier, there's no need to wait until that date, but there are a whole bunch of moving parts. I'm just looking at the number of PI cases. Those would be unindicted cases you've got. Ms. Hurwitz has some paperwork hunting to do.
Is that
Your
the
Honor.
29th? The 29th, sir?
Hold on.
Yes, it's the 29th.
Yes,
I was just asking her the next court date for you.
May 29,
May 29th?
right here.
Okay, yes. sir.
Okay.
All right.
Judge, really
Charlotte's-
quickly, I am supposed to appear in front of Judge Whitmer, I believe, or Judge Whitaker next week on Wednesday for the revocation hearing. I just would ask, will that case be transferred by that time, or should I just follow up with Judge Whitaker's court attorney, or how should I handle that?
So I will work with Ms. Nelson on my team to get that off her calendar. We won't move it here, meaning you don't need to be here next Wednesday for a revocation hearing. We would just ask to be able to handle the 24 SC revocation when we deal with Mr. Hassan's situation.
Okay, great. Thank you.
All right. All right.
Yeah. That's the question.
Mr. Abate, are you ready to handle the Mr. Bruce situation?
Yes, Your Honor.
All right. If you all don't mind, we just need 2 seats at the defense table. Ms. Hingerty, if you and Mr. Bruce would head on over to the defense table, please.
Is it okay if I send this new card back since this case is expired?
You certainly can. Yeah, I sort of want to say sorry, and understand. Okay, is something else holding him?
Yes, he's got 2 new cases.
Okay, then I just want to tell him that too, so we can do that next. We'll jump ahead. All right, Ms. Minifield, let's get on the record, please. This is 23 CP 217003, State versus Bruce. CP means unindicted, 23 means 2023. So this is a case that involved an arrest in 2023 that is not yet indicted. Mr. Bruce is charged with murder. I'm familiar with the case because it stays with me until it's indicted or it's dismissed. It was assigned to me for purposes of bond way back when. And whether it's been Mr. Weinstein or Mr. App or Ms. Hingerty, we've had a few hearings as there have been motions to modify the bond conditions. And Ms. Hingerty, I'm going to let you get on the record. I've got the motion. I've read it, and I think there's not a lot of opposition to it, but this is a real complicated situation. I want to make sure everyone has a chance to be heard. There may be family members of the deceased who want to be heard, and I will hear from them. But everyone should keep in mind that the purpose for today's hearing, other than me asking, is this going to be indicted, will be, do we modify the bond in this small ways that the defense is seeking to modify the bond 2 years and 10 days in. So, Ms. Hingerty, if you'd get us started, please.
Yes, of course. Good morning, Judge.
Good morning.
We have Mr. Asante Bruce. As you stated, this is a 2023 case. Mr. Bruce is now 23 years of age and still resides at the Grayson address in Windsor Creek. Judge, as you stated, this case has been open now for 2 years and 10 days without indictment. So at that point, we have not received discovery or anything like that yet from the state. At this point in time, with him being out on bond for such a long period of time and without indictment, we're respectfully requesting that his ankle monitor be taken off at this point, Judge. The state does not allege that he has violated the terms and conditions of his ankle monitor or the conditions as set out in the 2023 bond at all, not one time, Judge. We would like for him to have more freedom to work, more freedom to move about. And obviously he's here, he's retained private counsel and intends on fully seeing this case through, Judge. We're also asking that he be released from pretrial services and also released from the 24-hour house arrest. Those are our requests today. Again, he has not had any further violations. He's not had any violations. He's not had any further allegations of violations of Georgia code. And at this point in time, with the case not being indicted, we are saying that he deserves a reduction in his bond, Judge. We're asking for that today. If you have any further questions, I'm happy to do that. Happy to answer those, Your Honor. But that is our request.
Okay, I do have a few questions. So part of your request is not to have pretrial service supervision reduced to a lower level. It's to have pretrial supervision removed altogether.
At this point in time, yes, Judge, after 2 years.
Okay. And the address, you said something about Grayson. The address I've got is in Snellville. It's a Garrett's Way. And I may have the wrong address, or we may have modified the bond because family moved. I'm looking at the original bond. I know the conditions have been changed at least once.
Okay, I apologize. Yes, Judge. The address has been changed.
Oh, to Windsor Creek Trail.
Correct.
Got it.
Grayson address.
Yes. And that was in February of last year. It was one of our hearings we had. Okay, got it. Next question. You say 24-hour house arrest. That makes me think Mr. Bruce has never left his house other than coming to court. But I think he was able to be out of the house when he was working. In other words, if he had a documented job, I'm a doctor, I go to this building, or I drive a truck, and these are the hours I'm out. Is that correct? That he?
That's correct, Judge. He was allowed to leave the home for work and I believe medical appointments, but we're asking for some more freedom.
Okay. Is Mr. Bruce working?
You are, are you not? Yes, ma'am. Yes, you are. You can tell the judge what you do.
Yes, Your Honor.
I'm gonna ask you directly. Tell me what you do.
So I actually work front desk receptionist, and as well, when I'm at work, I just run data analysis and chart analysis. So if I work from home, it would be more so 10 to 3. And I work at Power X Insurance Bond.
That's the front desk receptionist work?
Yes, sir.
Okay, and where's that office?
It's located in Lawrenceville.
Okay.
Downtown Lawrenceville.
All right. And the ankle monitor you have, is that one that you and your family are paying for, or that the county has been paying for?
No, me and my family have been paying out of pocket, Your Honor.
Okay.
And
All right. And do you know if you are working with Talatrix / A&A, or are you working with Second Chance in terms of the monitoring?
so Your Honor, I believe it was Talatrix. But shortly after they began seeing A&A, so I'm not sure which one it is specifically.
Okay, but it's not Second Chance.
No, sir.
Okay. All right. Mr. Abadi, I'd like to hear from you about your thoughts about modifying the bond and any intel you've got. I know you are not the case indicter, but you can understand why I'm curious and likely the victim's family is curious.
Yes, Judge. So as it relates to the conditions of bond that are requesting to be modified, state obviously within full discretion of the court. We do understand that it's been 2+ years as it relates to when this case first became before Your Honor. I don't think I was here for any of the previous hearings, which is odd because I'm usually here for most of them. But what I can say in speaking with the indictment writing team is obviously this is as Your Honor alluded to at the beginning of this hearing, it's a complicated case. It's a case where it's clear that the scene was tampered with and which has made the investigation incredibly difficult.
Well, one of the defendants, I had to refresh my recollection about this. One of the people who was arrested actually had her bond modified partway through so that she and Mr. Bruce could have, they were supposed to have no contact. And then, so you have the added complication of people may have been or still are in a relationship. And
Right.
You're getting conflicting stories about what happened.
Very much so.
Yeah.
And the stories aren't matching as to the evidence on the scene, and it's clear that evidence from the scene that should be there is not there. But unfortunately, there's no video surveillance or anything from inside or outside the apartment. And the lack of cooperation has made it difficult. What I can say is that members of the DA's office have actually been actively investigating, talking to witnesses, and continuing to try to paint a full picture in order to make a decision as it relates to what charges, if any charges, would be moving forward with all of the defendants who were originally arrested, or not moving forward with charges. So I would say the decision on that would be made within the next 30 to 45 days.
Okay.
But I do understand, based on my calling, it is A&A. He's had no violations as it relates to his ankle monitor or any of his other bond conditions. So I understand that the state has actually put the court in a tough position as it relates to the length of time that Mr. Bruce has been under surveillance, for lack of better words, by pretrial supervision, as well as the ankle monitoring company. The family members of the victim, Mr. Johnson, are present. And what I'll say before I turn it over to them when the court deems appropriate, the state has definitely dropped the ball as it relates to speaking and keeping the family notified and in contact with them. And speaking with them this morning, the unindicted team has not been very
Communicative.
yes, at all. And the victim advocates have dropped the ball on that team as well. And so I know they would like an opportunity to address the court because they were not here when the initial decision as related to bond was made. And so they just would like to voice their concerns to the court, Your Honor.
Okay. Understood. I appreciate you sharing all that. Let me know from whom I'm going to hear.
Yes. This is Mr. Johnson's mother, and I'll let her state your name for the record.
Good morning, ma'am.
Good morning, Your Honor. I first want
You
to,
state your name first so
Oh,
we get that
yes.
in the record.
my name is Marlon Johnson. I'm DeRay Johnson's mother. My son, I just want to speak and address the facts. We have never gotten any communication with any court dates, that we weren't able to be present, to be a voice for my son, which is no longer here to speak on behalf for himself.
How did you learn about today's court date?
I had to come here personally because I have not been getting any communication from the detective, from the DA. We have been consistently reaching out. And there was we've had transportation issues, but I came here personally to get some answers. And unaware that I was aware that when I called before to the victim's advocate, about was there any updates, because I wasn't getting any communication from the detective, not even knowing that there's been our first detective, he never told us that he was no longer on the case, so that we had to find out from attending a support group that there was a new detective assigned to our case. And we spoke to her once. That's when the arrest was made. After a
Who is that
year,
detective?
Detective Summer Benton.
Okay.
Then it took a year from when my son was murdered, January 28th of 2022. It took a whole year for them to get an arrest and another detective on the case. Fast forward, after that happened, we heard nothing else from her with any updates. We weren't aware from the first bail arraignment that a person convicted or arrested for a murder should not have even been out of jail. They know my son and Mr. Bruce have shared a friendship. They have performed music together. My son has produced for him, was very supportive of his musical career. And my son, being my only son of 4 children, I have 3 daughters, he saw his friends as his brothers. He went to high school and graduated high school, went to college to pursue music, and was very passionate in producing, where he even had an opportunity to produce with artists such as Pop Smoke. I have a close relationship with his mother that we've spoken on things. My husband and I both been an educator, public school educators in the New York Department of Education. I've been an educator here in Rockdale County in Georgia. I'm very passionate about youth. My son and I actually started a nonprofit organization to help gun violence in communities of at-risk children. So he was very passionate about creativity, and he helped. And I also attended a performance of him and Mr. Bruce. So when he stayed between New York and Georgia, but when he only had been in town for 1 week, when my son came on a Friday, 7 days prior to the day that he was murdered at Mr. Bruce's apartment on a Friday afternoon. And ever since, our life has been in shambles. And we have not had any support, not only from the friends, no one has spoken to say anything. And the story that everybody came up to, kids that have spent holidays at my house, call me mom. All of them address me as mom. They never called me Miss Johnson, Miss Marlin. I loved and opened my home to all of them as if they were my son's brothers and my children, as I've always have. So to not get any cooperation from the system, and all I got was an apology for sending the bail arraignment information to our old address when we lived here over 10 years ago. They did not send us any correspondence, not knowing that there was not only one bail arraignment, but multiple hearings on behalf of my son's case that we weren't made aware to attend, not one. So because my beloved son at 23, I'm glad that you lived to see, he see 23 years, my son, his life was cut short, that he could not continue to work. He could not continue. I will never have a grandchild from him. He has a free opportunity to work, to have a job. There's people who are spending their lives in jail that have not even been affiliated and been innocent, but you've been a part of a criminal activity, been actively present in your home, that you're not been cooperative at all speaking. The least, while you do have freedom to work and to live a life, that he remains on an ankle monitor. I'm sorry that life has been inconvenienced for you to have something on your ankle, but our lives have been inconvenienced that we no longer have our only son.
Ms. Johnson, I appreciate you sharing that. It provides much more context. I'm familiar with the basic allegations from having read the warrant that Detective Benton wrote. And when we did have a hearing that you should have been at, you should have been told about, back in April of 2023, I learned a little bit more either from Mr. Abate or a colleague of his who would have been presenting on behalf of the state, and then an attorney for Mr. Bruce. And certainly, whatever happened that fateful day remains murky in the minds of those who are investigating it. I don't mean to suggest you have any doubts about what happened. My goal going forward in connection with you and your family and others who loved and cared for your son is that you always get notice of whatever's happening next. I'm going to invite you to call my chambers to get updates. I'll be the right place to reach out to until the case gets indicted, if it's indicted. I don't commit the state to any particular course of action. That's not what the courts ought to do. But assuming it's indicted, it will be randomly assigned to one of 15 judges. It could come to me. That would be pure coincidence. But what you'll want to do if it is indicted is learn as soon as you can, and you can call my chambers and we'll tell you, Judge X has that case. And then that's another point of contact you can always rely on is Judge X's, again, it could be mine, chamber saying what's happening with the Bruce case. And it could be Bruce and, I don't have the names in front of me, the two young ladies who were arrested for false statements and one for tampering with evidence, because where did all those shell casings go? And they're questions that need to be answered. If it's not assigned to me, you can always work with that judge's chambers for the simple purpose of being told what's happening next. I bet you, and I won't really bet you, but I suspect that Mr. Abate is going to make sure that the victim advocate unit in the district attorney's office, which generally does a good job. You are not having the experience I usually see, which is that's not meant to make you feel any better because you didn't get the treatment you should have and the support you should have. But I bet that Mr. Abate, who is a fairly senior supervisor, is going to make sure they are laser focused on keeping you apprised of what's happening, whether it's what you might view as good news, the case was indicted, or what you might view as bad news, we reviewed it and we're not moving forward with it. You're entitled to know, and you're entitled to say, well, I'd like to meet with the district attorney, and she may agree to meet with you, she may not, but point is giving you that information so you and your family can make those kinds of requests. I'm not offering an apology because I'm not the district attorney, but I'm telling you, I feel how you're feeling because not knowing is worse than good news or bad news. And it's been so long. So it shouldn't be that way. And you should feel free to reach out to my chambers unless and until we tell you now it's been indicted and it's this other judge. Okay?
Thank you so much.
You're very welcome. Thank you for being here. You may.
Good morning.
Good morning.
I am Andre Johnson. I am DeRay's father. As I sit here and listen to you, I hear that this system is failing my family. My wife just explained that we got no notifications of any court date. The only thing that we got was what we searched out and what we came down here to get. When this initially happened, we got a phone call from Mr. Bruce and his aunt. They explained to us that my son died in his arms. He explained to us a whole process of things that never happened. When I flew my son's body to Baltimore, my sister owns a funeral home. When I had a chance to view my son's body, it was inconsistent with the statements that he made to us. The reason why I know these things is that I'm a former Baltimore City police officer. As a preliminary investigator, I know some things, I know how some processes go. The information that was given to us from Mr. Bruce was just inconsistent all the way through. The information that we got from the young ladies was inconsistent all the way through. He knows what happened. They know what happened. So to sit here and complain that you have an ankle monitor on that's inconveniencing his life is a problem for me because I wear my son around my neck. And we wear our son, my daughters are here, that's their brother. We wear him around our neck and he's mad because he's inconvenienced, he can't go to work. Understanding the process, you can go to work with an ankle monitor on. You can do all the things that you want to do with an ankle monitor on. It only means that somebody knows where you are. Why do you want to get off the monitor? So no one knows where you are? You have family in New York. I believe he's a flight risk. The court may not agree, but I believe he is because he knows people, a lot of people all over the place. He knows these people. They've lied. So I believe that he's only trying to woo the courts. And the only reason why he's being good is because he's faking for the courts, because that's what they do. He has to fake for the courts to show that I'm being this good person, I'm being this. But no, you were part of a criminal activity. A person being charged with murder should have never gotten any bail. In Baltimore, when I was a police officer, if you're charged with murder, you never get a bail. This young man knows where we live. I have daughters to protect. I have a family to protect. I have a wife to protect. I have a new grandson to protect. I believe that this ankle monitor that he has on should be kept on. And it should be kept on because our lives have been inconvenienced. And it's been inconvenient to the point that where we grieve every single day. Grief is something that sneaks up on you when you think you're having a good day. And all the circumstances surrounding this whole thing this young man over here, the organization that they're a part of. My son is no longer here to apologize for anything. But we're here. We're still in pain every day. Counseling every day. We have to go through so many different things. We have to go into his room and see all his things every day. The reminder of a day that we lost our son. A reminder of something that happened that led to this that we don't know. Something that led to this, but we get a phone call. And then to go through being victimized again, not knowing any court dates, not getting any correspondence in the mail, not getting a phone call, having to seek it out on our own is a problem. So not only was our son taken from us, but there's been a misappropriation of justice on the courts because we don't know. We had to seek it out on our own. So today I'm asking you to, as a family, to protect a family. I'm asking you to please do not remove his ankle monitor. He hasn't been inconvenienced. He can still go to work. He can still do whatever. He just has to be monitored. Thank you.
Mr. Johnson, thank you for sharing that and for being here. I appreciate it.
And Judge, I just want to state for the record and for the court and for the family that the reason that Mr. Bruce has a bond is not because of any fault of your honors, it's the fault of the state. After 90 days, that Mr. Bruce is entitled to a bond, which is what your honor did and is what the court system requires. So it is all on the state as it relates to the custody status of Mr. Bruce. And honestly, it all stems from the investigation and the lack of cooperation, as I stated earlier. But the ball has been dropped by the state, not by the court or anybody else within the system. So I wanted to make that very clear to the family as well as to your honor.
Okay. Well, I appreciate that. It's not a blame game situation. I very much respect and understand the hurt and the frustration and anger that the family feels. That makes sense. There's nothing wrong with expressing it. What was wrong is that you didn't have an opportunity to express those feelings back in April of 23 when we had a hearing. But I do want to emphasize something that Mr. Abate said that's important to keep in mind. In Georgia, which is different from Maryland, under Georgia law, if a defendant is in custody for anything, murder, child molestation, shoplifting, and hasn't been indicted within 90 days, the court shall, SHALL, set a bond. Now, I could set a bond for $100 million, but that's not setting a bond, and that would get appealed, and that's not the way the system is supposed to work. And so there was a hearing in April of 2023 that the Johnson family should have been told about so they could be here. But I would have set a bond, no matter how impassioned you were, because I'm required by law. The district attorney's office of every county in Georgia is given 90 days to indict people. They can be held without bond up to that point. Day 91, by law, a court has to set a bond. I fashioned a bond that I thought made the most sense given what I heard, because there's another piece to this, and that's the Bruce family and the ability they have to put some guardrails around. And I am happy to hear, while you continue to be concerned, you have no reports that anyone from Mr. Bruce's family has reached out to you in an intimidating way or anything like that, which isn't to say you shouldn't be concerned. I hear your concerns. But we'd be having a very different conversation if you were playing for me a phone call that you got saying, you guys better back off, or we're watching you, or anything like that. Because if anything like that happened, there goes the bond. That's easy. Doesn't matter if someone's not been indicted for 900 days. If you violate the conditions of your bond, you lose your bond. But Mr. Bruce hasn't done that. Here's what I'm going to do. Mr. Bruce, I am leaving the ankle monitor on, but I'm going to ask Ms. Hingerty, because I'll enter an order to this effect, to work with you to get a different ankle monitor. You're going to switch over to Second Chance, and it's going to become a county-funded ankle monitor. So this clock that's ticking, Mr. Abate said that the office is going to be deciding which way it's going, indictment, not indicting, in the next 30 to 45 days. I am going to extend the ankle monitor requirement for 3 more months. We will have a hearing in 3 months to see where we are if the case hasn't been indicted. But I'm switching it to a county-paid ankle monitor. So there's still a monitor. It works the very same way. It's just not coming out of your family's pocket. I don't mean to put a financial burden on your household, and that's not sympathy for you in any way. I am hearing what the Johnsons had to say. We just reached the point where I didn't think you'd still be on an ankle monitor on a bond I set. You would have been indicted, or the state wouldn't have pursued the case, and a judge would actually be moving this case towards some type of resolution. But here we are 2 years later, and ankle monitors aren't cheap. It will still be an ankle monitor. And monitored in all the same ways. It's just something the county's going to pay for. I'm also removing the curfew. I got an ankle monitor. I'll know where you're going to be. But I'm taking off the house arrest piece. Everything else is still there. You still got pretrial supervision. I want them checking in with you. And more importantly, they'll let me know if you're doing something funky and going somewhere you ought not to be. The one guardrail I'd like to change is Mr. Johnson mentioned that Mr. Bruce knows where the Johnsons stay. I don't know if it's one household or multiple households. I also know Mr. Bruce is not in Fulton County. He's working not in Fulton County, living not in Fulton County. Do you all live in Fulton County? What county do you live in?
Rockdale.
Rockdale. Is Grayson in Rockdale County?
No, Your Honor.
No,
Okay.
they're not too far from each other though.
Okay. I'm talking to the fence here. What county do you live in?
Gwinnett County, Your Honor.
Okay. Do you have any reason to be in Rockdale County?
No, Your Honor.
All right. Then one of the conditions of your bond now will be that you stay out of Rockdale County. Don't go in there. Don't get a job that requires you to be in Rockdale County. Your ankle monitoring company will let me know if you are in Rockdale County. That would be a violation of your bond. That would be the end of your bond. So don't go into Rockdale County. Okay? There's just don't. Any other county works, but not Rockdale County. And I appreciate they're near each other, but that is a layer of security that I think is appropriate to require, even though we're more than 2 years in. The warrant was a year later, and it was helpful to be reminded of that. We're 3 years into this process, 2.5. So, Ms. Hingerty, I'm granting the motion for modification in that we will switch the monitoring company to Second Chance. It'll become a county-funded ankle monitor, and I'm lifting the curfew, maintaining pretrial services, and adding the requirement that Mr. Bruce stay out of Rockdale County. I'll get all that in writing and enter a bond modification order to that effect. And then you'll just want to work with Talatrix, which owns A&A, and Second Chance to figure out how to do that swap. And until you do the swap, you'll be paying for the Talatrix one. So you have a financial motivation to make that happen. And you'll just need a copy of the order that I'm entering, modifying the bond, saying it's becoming a county-funded one. They'll see that order, and Second Chance will fit you with an ankle monitor, and then they bill the county. And then finally, we'll have this on a calendar 3 months out to look at it again. I'm not interested in spending county money indefinitely. The state needs to decide which way it's going. And that's not an easy decision, and they'll need to talk to the Johnsons about that. But they'll need to talk to the Johnsons about that. Mr. Abate, anything else in this case?
No, Your Honor.
Ms. Hingerty? Mr. Bruce, do you have any questions about anything I said? I don't want us to have a hearing in a month where you say, wait, I didn't understand Rockdale means Rockdale.
No, Your Honor.
You got what you need to do.
Yes, Your Honor, I'm clear on that.
All right. Mr. or Ms. Johnson, any questions about anything? For me, you may have lots of questions for the DA's office, but you can follow Mr. Abate out of the courtroom. You're good? Enough? Okay. Thank you for being here.
Judge, can I be excused?
You may.
Judge Wall?
You go wherever you need to go. Thank you.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Thank you for being here. You guys are waiting a second though, I think.
You can have a seat. I'm actually gonna run out to the hallway.
Okay, you're gonna do what you need to do. All right.
I'll meet you in the hallway when you do it, okay?
Okay. All right, we were going to bring Mr. Clark, Christopher Clark, to the door. Hey, Mr. Bruce, you're supposed to sit tight for a sec. Don't, just take a seat. He'll let you know when you can go. Thank you. How long ago did Mr. Clark's case expire? This is 2 days in a row where we've had.
A year, Judge.
It expired.
Okay. Hey, Mr. Clark, I'm Judge McBurney. I just want to let you know what I know Ms. Wood has already told you. I had you on my calendar because I signed a warrant back in April, 3 years ago, April of 2022, in your old case, and you supposedly violated your probation. That case is closed out. It's expired. So I'm going to make sure that warrant gets taken out of the system and isn't around anymore. I know you've got a new case here and a new situation, and that's why you're in custody. But in case you were thinking, well, what if I post bond? I've got this probation warrant. We're getting that removed from the system. You won't need to come back here to deal with that at all. That case closed out a while ago, okay? You're welcome. Good luck with other things. You too. All right. If we go back to our regularly scheduled calendar, Mr. Hassan, we're resetting. So that gets us to Elijah Jackson. Ms. Wood, your case.
I was just seeing his mom. Remember Jackson? Yeah. Okay, perfect. Judge, if we could come back to this one, I just need to speak to her briefly and then I'll be ready.
Okay. It's a bench warrant situation. Are we resolving it or we're just talking about the bench warrant?
Also, I'm gonna speak to Ms. Dilligard really quickly and then, but if not resolving, then it'll be a bench warrant.
Discussion. Okay, we'll come back to that. And then I assume unrelated, Daniel Jackson?
Yes, Daniel Jackson is my case as another bench warrant situation. I filed a motion to set aside his bench warrant.
Yep, I've got it right here. And we will talk about that when you're ready. And is that all we're talking about?
Yes.
Okay. Is this Ms. Charles's case? Okay. Are you ready to do Daniel Jackson right now? The state's ready. Are you ready, Ms. Rios? Let's bring Daniel Jackson out, please.
Pretty to this.
Oh. All right, let's chat a little bit. Mr. Jackson, how are you doing?
I'm doing great, Your Honor. How are you doing?
I'm all right. Let me get your case up on the screen here. So Ms. Rios filed a motion to have me set aside your bench warrant. You had a plea and arraignment in early March of this year and you weren't here. So Ms. Rios, tell me why you think the bench warrant should be set aside.
Yes, Your Honor. During that time, it was 4 years ago and he was homeless at the time. He was locked up for, I think, 3 months and he lost his apartment and his home. And so.
You said 4 years ago.
I'm sorry.
But I'm confused. Like this arrest was just around Christmas time of last year. So everything is pretty fresh.
Okay, during the time, I think I was confusing him with my other David Daniels case when I said 4 years ago. I'm sorry.
Okay.
But during the time that he was locked up, he lost his home and lost his apartment. And so that's why he was homeless at the time and he did not get notice of court. And he wasn't checking because it was dismissed at prelim.
Okay. So the address I have in the court system is in Savannah. Are you from Savannah?
No.
I just filed that change of address because that's where he'll be staying once he gets out.
Got it. The new address is Savannah. The old address now isn't in the system because you did a change of address. Okay. So you were arrested on the 22nd of December and released in February. And just 1 month later, we weren't able to track you down. Where did you go when you got released?
I stayed in a weekly stay, but I said I never talked to my attorney or I never came, like when I was during that arrest, I never stepped foot in the courtroom. I never talked to my attorney or the judge. They just kept on postponing it, and then I went. They said it was dismissed. So
Okay.
when I did get out, I did go to a weekly stay trying to get my set back together. I did pick up a job in that time frame too.
Got it. So you didn't have a stable space when you got out?
No, not at that time, no.
Okay. Yeah, I'm looking here. Judge Brooks in February of this year dismissed the case because the officer didn't show. So your charges were dismissed. You're probably thinking, great, this is done, it's gone. And lo and behold, 2 days later, it got indicted. So the charges are still alive. And you need to work through all that. Yep, it's from December 22nd. You do have a bond, a $75,000 bond. So but the charges, you have no bond right now. I guess that's another issue. If the case got dismissed,
Yeah, I had no bond whatsoever.
there'd be no bond, I think. You never posted a bond.
No, I never posted. a bond.
Okay. So there is a bond you could post, but I guess we'll need to think through what that bond really means. It's the same charges, but they were associated with charges that got dismissed. So at a minimum, we would need to talk about setting a bond, but have to decide whether I'm setting aside the bench warrant anyway. Who is in Savannah?
It's my cousin.
Okay. What other connections, if any, do you have to Savannah as opposed to Atlanta?
I have none. I have an uncle that's closer in the metro area. I don't have my phone or anything, so I couldn't get his address. But I say I do have my uncle, a few other cousins, but that's the cousin the number that I knew off rip that I could give and call and get an address from. But
Okay.
I have no other than him, him and his wife. That's kind of really it in Savannah.
Got it. Let me check one more thing, and then I'm going to hear from Ms. Charles, who's the prosecutor on your case. excuse me, and we'll figure some things out. So, tell me what's at Ivy Chase Way?
That was my last address. That was the address I stayed at the time of the arrest.
Okay, meaning in December, when you got arrested, Ivy Chase Way was where you were staying?
Yes,
Okay, is that an apartment?
yes.
Um,
We don't have an apartment address, but it is like an apartment complex.
Okay, that's an apartment complex. Were you still able to stay there when you got out?
No.
Why not?
Cause I said I missed the January and February rent, and then they, like I say, by the time I got out there, they told me that all my stuff was put out.
Okay, all right. So Ms. Charles, you don't have to sit way in the back like that. Come up to your table. Notice was sent to Mr. Jackson, but it was sent to the Ivy Chase Way address. And so my records say he didn't get notice. And you may agree with that, I don't know, but the notice that the clerk's office sent out went there. There was one other notice sent out. Let's see where it went.
So I have a paper from him saying the notice went to a 390 Campbellton Road, but that's the victim in the case address, and he wouldn't be able to.
Hope he's not getting anything from there.
Well, it's just, they're still sending notices to that address.
Yeah, well, what's the date of that notice?
16th day of April.
So that's for today's, the one that mattered for the plea and arraignment date was sent to two places, to Mr. Cazzoli, who is a colleague of yours, and then to an address that was no longer a good address for Mr. Jackson, the Ivy Chase. Ms. Charles, tell me what you think we ought to do.
Your Honor, I think Mr. Daniel Jackson, should be held in place. Although notice wasn't good for the original address, the state isn't comforted now that his housing situation has improved any. When we received notice of the filing, we were able to briefly look at the Savannah address. It's an apartment complex, the Arbor apartment, but there was no apartment listed. Based on what is represented today, it doesn't seem that that is a cousin. There's some significant ties to that address. Also, Your Honor, I do want to make the court aware that in November of 2024, there was an open strangulation case in the state of Indiana where he was arrested for having assaulted the same victim in this case. He also is not originally from Georgia. He's from the state of Michigan, if my information is correct, where he has multiple felony convictions for armed robberies and weapons charges. The state has tried to reach out to Ms. Galmore. We sent messages, also email. She hasn't responded to this day, but she has reached out to defense and sort of indicating her wish not to proceed with this case. And so the state is sort of concerned that on the face of the facts, this case is easily resolvable, but based on when Ms. Galmore is representing to Ms. Rios, that she may be influenced not to participate with the prosecution of this case. And so we would like some more time to continue to make efforts to reach her. And to the extent of bond isn't set, we would think he's not a good candidate for bond as of now, since he hasn't demonstrated any improvement in his housing situation, clear ties to Georgia, and I believe he poses a risk to influence the voters.
Okay.
May I respond?
Of course, you always get to respond, Ms. Rios. We do need to set a bond, whether it's resurrecting the one that Judge Brooks set or what, but what is your response?
As far as the intimidation, I don't believe there's any evidence of that. I said, usually there's been several times the victim is easier to get in contact with me than that if from the state. I had another victim outside who's been trying to reach the state and they haven't talked to anybody. And so she's called me and said she's tried and hasn't been able to. I don't believe there's any evidence that he's trying to intimidate her. She just said she doesn't want to go forward with the charges. As far as stableness of address, he gave me a number. I wasn't able to have time to call the cousin yet, but it's an address in Georgia that he can go to. He had other people that he could give me, but he didn't have those numbers, so he didn't give me those addresses that were closer into the area because he knew I could verify this one. So he has no plans of leaving Georgia. He has no plans of not resolving this case. He's not trying to run. And when I talked to the state earlier this morning, she did indicate that this case would be an easy resolvable case. She just needed to talk to the victim. So I don't see the purpose of keeping him in custody if this is probably going to be a probation outcome anyway. That just seems like more like punishment than anything. Since he did not get notice of the address, he wasn't trying to avoid coming to court. He could not come to court. And I would ask for us to also set a bond in his case. He has one son that's 7 years old. Prior to being in custody, he was driving for Lyft, correct?
Yes.
Yeah, he's doing Lyft driving, and he's going to try to get back to that. I know there is a baby on the way in June, so he wants to be able to work, and so he can help financially provide for that child.
Okay. Mr. Jackson, do you feel like you would be able to give enough information to Ms. Rios that she could track down this uncle? You mentioned you've got an uncle who lives closer.
Yes.
I'm not comfortable with the Savannah address. It's not a knock on the cousin, and Savannah's a great place. It's too far. And so my plan is to reinstate, and that's the wrong verb. I'm going to talk with my litigation manager to see if I need to do a new bond. It's going to be the same thing Judge Brooks did. She had a bond hearing. She heard more about it. But I'm going to put in there the address where you need to stay. And that needs to be one that is closer, that pretrial services can verify. And so you mentioned an uncle, and that closer to, it doesn't need to be in Atlanta proper, but closer than Savannah.
Yes.
But you don't have your phone, so you're not able to track your uncle down. But hopefully you could get Ms. Rios or her investigator in touch with someone who could find your uncle, who could say, hey, could Mr. Jackson stay here? What's the address? Because I need that to be in the bond, so I know what the situation is.
Okay, yes, I can, like I say, I can try to reach out to him. I know, like I say, he is on my dad's side, so like I say, my mother and them don't kind of reach out to him. I came down here and like I say, and kind of reached out to him. So he, so I did talk to him, but he is in my phone, so I don't know if I just have to get, I guess, the copy of my phone. And,
Okay, whether it's that, you get your phone to the public defender, or you get your lawyer in touch with your dad, or I'm gonna let you guys sort that out. It just needs to be an address much closer than Savannah, and we'll move it forward that way.
Okay.
Okay? Ms. Charles, anything else?
Oh, no, Your Honor, thank you.
Ms. Rios, if you're comfortable, you might help move the case along, assuming Ms. Garamore, if I'm saying the name correctly, if you got her contact information to Ms. Charles.
I texted to her.
You did, great, thank you. All right, anything else, Ms. Rios, on behalf of Daniel Jackson?
No, Your Honor, thank you.
All right, thank you.
Your Honor, I have a brother, may I please speak to you?
You may. Wilbur Alford. That's Ms. Rios's? Okay, we'll come back to that one. How about, man, if this Bainbridge is on, let's do Bainbridge. All right. Hey, are you Mr. Essic?
Yes, I am, Your Honor.
Great. Give me 1 second, Mr. Essic, and we'll take care, we'll at least explore your situation.
Sir.
Judge, I think I filed a waiver in this case too. I think we need to go over that also, because I think you will increase for being informed, but.
When you say go over it, I just made a note, we need to do a scheduling order.
Okay.
Yeah, so I just saw your waiver. I was realizing setting a bond is only part of it. How do we move it forward? You did your waiver, so we'll do a scheduling order and that'll move it along.
We're good. I'll that's for it.
Okay, Mr. Essic, good morning. I'm Judge McBurney. I took a quick look at your case file. Old case. You mailed something to us that got filed in March where you are asking something to happen with your old case. You want to let me know what you're trying to do and we'll see if that makes sense.
I was trying to resolve the probation violation warrant.
Okay. I don't think I got a warrant. Do you have a warrant for Mr. Essic? Okay. Mr. Essic, you are at Bainbridge. How long have you been there?
3 months.
Where were you before that?
Macon,
For how long?
a year.
And what are you in for?
Burglary,
From what county?
Macon.
Okay. Ms. Wood, you seem familiar with the situation.
Judge, so I have not met Mr. Essic. Good morning, Mr. Essic. But Ms. Simpson and I have been working on this case. This should resolve today. He's got a lot going on in Macon-Bibb County. So the offer is essentially revoke 4 months, which is essentially time served, and then close this case out so he can focus on his treatment at RSAT and then worry with his Bibb County probation matters.
Okay. Mr. Essic, are you based in Macon or are you, like, if you got out today, would you go to Macon or would you come to Atlanta?
Atlanta.
That's where home is?
Yes, sir.
Why do you have so many cases down in Macon?
I was staying in Macon. I went to Macon for treatment, but I relapsed.
Okay.
I had left. I was sober living of America, and they sent me to Macon.
Got it. Okay. How is RSAT going?
Oh, it's going great. I'm doing well here.
Good for you. So let's start with the basics. Ms. Simpson, how much time remains on Mr. Essic's 15 SC case?
9 years, 4 months, 27 days.
Does he have Macon cases that are going for a while so that if this one goes away, he'll be in good hands with DCS?
Yes, Judge. Yes, that's 5. One of them being consecutive, start till 334.
Okay, so if probation is appropriate and necessary, those cases out of Macon will keep him supervised. They may be supervised here if he moves home, but this is cumulative. Got it. Okay. And what is the supposed violation that we're working through?
Is it the Macon case law?
It is for failure to report, failure to complete the ERC, and he picked up the misdemeanor theft by taking part.
Okay. Hey, Mr. Essic, way back when, do you remember being asked or told to participate at the Day Reporting Center here in Atlanta?
Yes, sir.
Okay. All right. Well, why don't we go on the record now that I better understand what we're doing here. This is 15 SC 136190. It's State versus James Essic. He is appearing remotely from Bainbridge. His lawyer, Ms. Wood, is here in court. Mr. Essic, do you waive your right to be appearing here in open court?
Yes, Your Honor.
Okay. You also have a right to have Ms. Wood by your side rather than here in court and sort of virtually connected to you. Are you okay if we proceed with Ms. Wood here rather than there in Bainbridge?
Yes, I am.
Okay. If you need to speak with her privately, let me know. It's my understanding, and I'm about to look at it, that here's your warrant. Judge Reeder, who's my predecessor on these cases, signed a warrant in 2019 that alleged that you failed to report In other words, you walked away from the MADRC, day after Christmas was your last day you went. They couldn't track you down, and then you got arrested in Cobb County for a shoplifting situation. All this is back in 2019. It sounds like Ms. Wood is recommending that you stipulate to those violations. And then what she is also recommending is that I revoke 4 months for that, and then close out your 15 SC case, so that that's just not probation you need to worry about anymore. You'll have plenty of probation for your Macon cases. Does that seem like a reasonable outcome to you, Mr. Essic?
Yes, sir.
Okay.
Yes, sir.
Ms. Dilligard, do you have any concerns with that?
No concerns, Judge. That is the intent of the state as well.
Okay. All right. Ms. Wood, anything else on behalf of Mr. Essic?
No, Your Honor.
So, Mr. Essic, I find that you did back in 2019 violate the terms and conditions of your probation in this case from 2015 by leaving the day reporting center, kind of disappearing, we call it absconding, and picking up those new charges in Cobb County. And in light of all that, I'm revoking 4 months of your probation in this 15 SC case and closing it out. So you don't need to keep track of it. We don't need to keep track of it. And frankly, all your court business will be making court business. So if there are issues a year from now, 2 years from now, and I hope there are not, then you just be in front of that judge in Macon Bibb who's been handling your cases. Okay?
Yes, sir.
Anything else, Mr. Essic, you were hoping we would do today?
No, sir. I'm fine.
All right, Ms. Wood, anything else on behalf of Mr. Essic?
No, Judge, thank you.
Ms. Dilligard?
Nothing further, Judge.
All right, Mr. Essic, you complete that RSAT, okay?
Yes, sir. Thank you very much.
All right, thank you, Bainbridge, for making the connection. Ms. Rios, you had been having final words with Daniel Jackson. Are you ready to go forward with Wilbur Alford? Ms. Wood claimed that was yours. Number 4? Doesn't sound like it. If you want to study that one, who's handling Eugene Alexander?
He's mine, Judge, and we can bring him out.
That's a conflict.
My bad.
Oh, wait, Eugene Alexander is?
Alford is a conflict. I have a lot of line of Gates.
Elijah on Gates.
And I could put-
Yeah, we're not to the, oh, okay. We'll hold on to him till we get to Gates. That's on the add-on. Can we do Eugene Alexander? Sergeant Palmer's gonna get whiplash here going back and forth. Mr. Alexander, hopefully he's back there. And I have a warrant for him, so I got my paperwork.
Oh, my bad.
It's okay.
Didn't prep my calendars thoroughly today.
Why does he always take so long to bring people out? You should do it. Yeah. Hey, how you doing? Good to see you. You take so long. Hey, Mr. Alexander, come right up to the podium, please.
How you doing, sir?
I'm all right. We're going to get on the record in your case. Your case is 16 SC 147220. You are represented for purposes of this revocation hearing. That's what we're here for today by Ms. Wood. Ms. Dilligard is the prosecutor on your case. And I have a warrant that I signed in March of this year in your case that alleges that in February of this year, you picked up new charges, trafficking drugs, which is serious, and a couple other things, possessing a gun, et cetera, all here in Fulton County. You were on probation for some drug charges. You got a little more than 6 years remaining on your probation in this old case, facing these new charges. Ms. Wood, tell me what you're recommending we do.
Thank you, Judge. We are recommending that you revoke 65 days and reinstate. I forgot to check to see how much time is left. He does have
How much time is left? What?
on this probation.
6 years and 3 months.
This probation was from 2011?
This is from 2016, correct, Judge?
Correct.
Yes, this is a 2016 probation case.
You have a lot of cases?
No, sir.
Okay. So I'm going to give you a little refresher on your case. I don't know why we have this. It says Judge LaGrua on it. But you got paroled out in 2019 on this case. Let's see if we can find the final disposition. Here it is. You pled guilty in November of 2016. To possession of cocaine, 15 years to serve 5, 10 years on probation. And you went to prison. Even though it says LaGrua, I'm the one who signed it. I guess it's because you were in drug court. We must have dealt with each other in drug court. I'm sorry for not remembering all that. This was a little while ago. So that was your sentence. And you're still on probation for it. More importantly, you got picked up a couple months ago for drug trafficking. What's the status of those charges?
Bond out on it already, sir.
Judge, so the jail records in Odyssey are showing that the bond has yet to be posted. So I'm not sure what that means, but it's showing that he still has to make a bond on that case.
Yes, my bond was paid.
Do you have a PI number?
Yes.
March the 21st.
25 PI 001520.
Mr. Alexander, Ms. Cooper, and Travis Grant. Okay, here's Mr. Alexander. You got a bond set about a month ago.
21st of March.
Okay.
It's already been paid already.
You got a $35,000 bond that Judge Hughes set. So yes, you've got a bond.
It's been paid already, sir.
Okay, I'm not doubting you. It may well have been. I just wanted to see what the status is. So your lawyer waived preliminary hearing. You got a bond magically the same day. And I guess that was a bond reduction. Oh, you had no bond originally. And then time passed and you got the bond we just talked about. Okay. Why is 65 days and that's it something that you think makes sense for someone who was on bond for drugs and then, meaning distributing drugs, and then picked up these new charges?
Judge, this is non-negotiated. I expect the state will have a much different request of the court.
Got it.
And I did just want to share, because Mr. Alexander had said that he was not on probation. Part of the confusion is he was actually on non-reporting probation upon release in 2019, Judge.
When he got paroled?
Yes.
He didn't go to unsupervised.
He was supervised for a few years and then a couple of years ago he went to unsupervised. Okay. All right. So I didn't realize it was non-negotiated. Let's also make this clear on the record. Mr. Alexander is stipulating to the arrest
Yes,
for purposes of this. So, Mr. Alexander, you're not admitting that you trafficked drugs on February 26th of this year, but you are stipulating, hey, I got picked up and wrong place, wrong time, wrong people in the car. I don't know what the deal was, but you certainly got a serious arrest that will go wherever it goes. And your lawyer is recommending effectively time served. I think she said 65 days. You've served 63. I get the thrust of what she's asking for. You understand that that doesn't bind me. I could revoke more time or less time.
Yes, sir.
Okay. All right. Let's hear from Ms. Dilligard.
Judge, the state's recommendation is to revoke 4 years. I think probation's original intent was to revoke the balance. However, we came to the agreement to ask this court to revoke 4 years based off the seriousness of the new offense, that he was on probation for similar charges, and then during a review of his criminal history previous to, other than this case before this court, I counted 5 other drug convictions, with 3 of them also being with intent to distribute. So with all of that taken into account, the state's recommendation is to revoke 4 years.
Wrong place, wrong time.
Okay. I was just looking at your arrest affidavit, so I could understand a little bit more about how you wound up getting arrested in connection with this. Mr. Alexander, I'm inclined to be more in the range of what the state's talking about. And so I want to give you and Ms. Wood an opportunity to say, we want an evidentiary hearing, or look, I know what that's going to be like. The officer's going to come in and say, I did a search warrant, and Mr. Alexander was there. Some of his documents were there, 184 grams of MDMA. There was a gun, there was cocaine, 2 firearms. So we can, I'm fine either way. I don't want Mr. Alexander to feel like he's railroaded, because there is a wide gulf between time served and what strikes me as a not unreasonable recommendation.
Yes, sir. Do you want to talk to someone in the back?
Why don't you guys talk for a little bit? I'm fine, Mr. Alexander, going forward today. I don't want you to think that tomorrow I'm going to change my mind. The only thing that would be different is if you wanted an evidentiary hearing, the state would be required to bring a witness in. It's a lower standard of proof. It's not like a trial. It's just, is it more likely than not that you violated your probation? And so if Investigator Noble came in and talked about the search warrant and how that went down, and it was credible, then I might find that it's more likely than not that you did these things that you got arrested for. You also may decide you want to try to work everything out at once. In other words, the state could accuse what you've been arrested for, and you're pleading to that as well. But I'm here just to work through what you decide. We could go forward with the proceeding today, knock out that revocation, and then you can deal with the new charges as they move forward, or, like I said, have the evidentiary hearing. But I'm gonna have you and Ms. Wood talk about that. I get it that none of them is a happy choice, but you need a chance to talk with your lawyer about it, okay?
Thank you, Judge.
You bet. Ms. Rios, do you have a case we can do while Ms. Wood and Mr. Alexander are talking?
Yeah, I think the latter one, we can just quick, since.
Okay, before we do that, Ms. Rockwell she poked her head in, she went away?
She texted me that she had to run to another courtroom that she'd.
Of course. Okay, we'll come back to that. Is that one that you and she have worked out, or it is akin to Mr. Alexander's situation?
Akin to that, I do believe that we were addressing maybe a temporary release on that one for a funeral. Is that?
Oh, that's this case. Yes, sadly, his father passed away. And so we're gonna at least let him out for a couple days. Okay, all right, we'll do that. Are you all here for who are you here for? You're all here for Mr. Hayes. Okay. We just need Ms. Rockwell to get here, and we can figure out how to navigate. I'm sorry for your family's loss. And we'll get Mr. Hayes out briefly, so that he can be with the family during that period of grieving. But he's gotten himself into a pickle that probably is gonna mean he comes back. But we'll talk about that once Ms. Rockwell gets here. All right, you want to talk about Olajuwon Gates while we're waiting for lawyers? And he's in custody?
Yeah.
And what are we doing today with Mr. Gates?
I filed a waiver on both the cases and we have to set aside the bench warrant situation. He was in custody.
Okay, so we're just working through why he missed court.
Yes.
Okay. Can we bring Mr. Gates out or we can't have Ms. Wood back there? I just need you to multitask, not in like 30-minute increments, but like if we could get Gates, Olajuwon Gates. Hey, Mr. Gates, come on up to the podium, please.
Hey.
Mr. Gates, you've got a couple cases here. Both are drug charges. One involves more drugs than the other. And you, I guess, missed court at one point. And I signed a bench warrant. And we're going to talk today about whether I should set that warrant aside and how we move forward from there, okay?
Yes, sir.
All right, Ms. Rios, get us started, please.
Yes, Your Honor. Mr. Gate missed court because he was in Dodge State Prison. I believe I emailed this paper that he gave me showing that he was not released until April 10th and brought here.
April 10th is in like 20 days ago.
Yes, and he was brought here from there.
Oh, what were you doing in Dodge State Prison?
Probation.
Okay, probation violation, so revocation. And that case was from where?
2021, 22.
But what county was it from? Fulton County. So you got revoked for something.
Yes.
We're doing that time. We didn't know that, so we were looking for you in court, but you couldn't be here because you were in Dodge State Prison.
Yes, sir.
Are you done with that revocation?
I think I have like 6 more months on that revocation.
So how'd you get here?
I had 1 year, 2 months, 11 days left. She revokes, she gave me credit time.
Got it. I didn't ask the question well, but the revocation part's over. Like you're not going back to Dodge?
No.
For now?
No.
Okay. All right. And were both of Mr. Gates's cases on for that same day?
One case was transferred over from non-complex.
Of course it was. Okay. There it is. Okay, that just got here. So the 073 is new to us. You've done a waiver in that, and we got it from non-complex. And then the 975 will need to You did a waiver. Okay, so we'll need to do a scheduling order for both those. What's the bond situation? It looks like Mr. Gates received a bond. When did you go to Dodge?
After Christmas, December 26, 2024.
Oof. So you were home for Christmas and then the very next day?
No home for Christmas. I went down to Jackson November 19th.
Oh, okay.
5 weeks in Jackson. Then
Huh.
they shipped me to
And then, okay. And who was the judge who revoked you?
I don't know her name.
Okay. Didn't make a good impression on you? All right, so you have a $35,000 bond in the case that's always been with us, and then you clearly had a bond on the non-complex one. Okay. Ms. Dilligard, have you had a chance to look at the paperwork about Mr. Gates's whereabouts?
I did, yes, Judge. The paperwork that Attorney Rio sent me, I did confirm
Right.
he was incarcerated.
You concur that it shows that he was unavailable for court?
Yes, Judge.
Okay, it just arrived here. Why is it all torn up?
Well, that's what he gave me.
Okay. You went to boot camp?
No, prison, they ain't go to boot camp.
It was just Barwick.
Yeah, Judge Barber.
Wow, Judge Barwick revoked you. Must have.
But it wasn't her. It was a
Some other judge?
Caucasian lady with long hair with glasses.
Okay,
She did the revocation that day.
okay. I'm just trying to not. What on this piece of paper says when he went in?
That was a little confusing for me too.
A lot
I wasn't able
confusing.
to determine that. I tried to look it up in the paper.
Oh, maybe it's this custody date of October 11th, 2024. Is that, you got picked up in October and then got,
Yeah.
okay, I can also, let me look up. 182619. Okay. That was what happened. Judge Barwick revoked. So it was Judge Mao. So you must have been on one of those Friday calendars. Yep. Okay. And you got revoked 6 months. That was, okay. So that's then on this form. Let's do this. Where's that form? Annotate. So this is the start date here. And that's when it would have been, that was here in Fulton County. You went into custody and started getting credit for the 6 months.
Yeah.
And then you got out in April.
That's why they gave
More importantly, our court dates are in between that start date and that end date. And that's why we didn't see you. Okay. Then it seems like I ought to set aside the bench warrants and the old bonds kick in. Do you have other things holding you?
No.
Do you have a place to stay?
Yes, sir.
And is that in the Atlanta area?
Yes, sir.
With whom?
With my sister.
Okay. All right. We've got a waiver in both cases, so we just need to do scheduling orders and move this along.
Yes, Your Honor.
All right, Ms. Dilligard, the scheduling order will be the sign for you to get discovery to Ms. Rios, and we'll go from there. Anything from the state? All right. Any questions, Mr. Gates?
The bond?
Your old bonds are in place. You just need the warrant removed, and we'll take care of that.
All I have left, whenever you're ready, is I have a plea ready to go.
Okay. And is that on Branyon Ingram or David Allen Daniels?
David Allen Daniels.
Okay. Do you have also Branyon Ingram, or that's not your case?
Mine.
Okay. Ms. Wood, should we do this plea because you are doing other things, or should?
Yes, you can go ahead.
Okay, why don't we do that? So if we could bring David Allen Daniels out, please. I think it's Daniels. Palmer.
It's David Daniels.
Are you Mr. Daniels?
Yes, Your Honor.
Great. Come right up to the podium.
Okay.
I'm good. How are you?
That'd be better.
So when you get out, go to pad first.
Okay.
These are the hours for pad. After pad, go.
Ms. Dilligard, you can stay right there since we've got a remote court reporter,
Okay,
if
and I
that
did
works for.
like him.
Oh, right, I forgot about the neck. Yes, if you don't mind.
Okay.
Thanks. I always think about that the wrong way.
To get everything transferred over.
Okay.
And then you can go back to court if you want, or stay here. I don't know
Okay.
whatever you want to do.
How do I check in with probation?
She'll tell you.
Okay.
And Your Honor, can I get the defense attorney's name, her name?
Yep, I'll get all that on the record. It's Ms. Rios, Rios. Her first name has lots of letters in it, but it's Ms. Rios.
Thank you so much.
You bet. All right, let's get on the record. This is position 4 from our add-on calendar. It's 23 SC 191227, State versus David Allen Daniels. Mr. Daniels is here in court with his lawyer, Ms. Rios. Ms. Dilligard is representing the state. And Mr. Daniels, Ms. Rios tells me you are prepared to enter a plea in the case. Is that correct?
Yes, Your Honor.
All right. The way this will work is that Ms. Dilligard in just a moment will put you under oath, ask you a bunch of questions about your rights as a criminal defendant, et cetera. You need to answer all those questions. You also need to let me know if you have any questions about anything we're talking about. Will you do that?
Yes, Your Honor.
Okay.
Thank you.
You bet. When you're ready, Ms. Dilligard.
Mr. Daniels, can you please raise your right hand? To
Yes.
the best of your ability. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
My true and correct legal name is David Allen Hubbard.
Is Daniels,
That's an alias name from long time ago.
Okay.
I tried to I came in with a state ID too, and I let the jail know. They said, nope, we're keeping you under this name.
okay, but Mr. Hubbard, like your birth certificate and your family would know you as Mr. Hubbard?
Yes, Your Honor.
Okay, well, we'll add the AKA Hubbard to all this.
Yes, Your Honor.
Mr. Hubbard, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you've not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I am 35 years old, ma'am. I've completed my high school diploma and a little bit of technical schooling.
You understand that you've been charged with the following offense. It's 1 count of burglary in the 2nd degree.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am. I understand.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances related to that charge?
Yes, ma'am. I'm very thankful for the work that she's done. She's been very good.
And so you don't need any more time to discuss the case with your lawyer?
No, ma'am.
And you're satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading the indictment and waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Hubbard, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for this charge?
Yes, ma'am.
The minimum being 1 year and the maximum being 5 years?
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. Judge, the recommendation is to plead guilty to the burglary in the second for a sentence of 5 years to serve 50 days. On the condition that Mr. Hubbard receive a drug and alcohol evaluation and any treatment that is prescribed. For Mr. Hubbard also to continue to attend his monthly AA meetings and 50 hours of community service.
5-0?
Yes.
Okay.
Is that your understanding of the recommendation?
Yes, ma'am. Just one clarification. Is that guilty under Albert?
Alfred.
Oh, Alfred. Sorry, ma'am.
Yes, you'll, when she asks you
Okay.
everything you said.
Okay.
We're not there yet.
Yes, sir. Yes, Your Honor.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anyway?
No, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am. I understand.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and their right to appeal if convicted of these charges at a trial?
Yes, ma'am. I understand.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Are you, is it your decision to enter a guilty plea because you're in fact guilty?
Guilty under Alfred or Albert?
Alfred.
Alfred. Okay. So I keep saying it wrong.
We know what you mean, though.
Thank you, Your Honor.
Are you pleading guilty because you've decided that it's in your best interest to do so?
Yes, yes,
And
ma'am.
are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted of by a jury at a trial?
Yes, ma'am.
Mr. Hubbard, how do you plead to the one count of burglary in the second degree in indictment number 23 SC 191227?
Guilty under Alfred, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that you have, for a felony charge, you have 4 years from today to file that petition?
Yes, I understand.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on June 7th of 2021, APD responded to a report of a burglary at Opium Lounge located at 50 Upper Alabama Street in Atlanta, Georgia. The manager had Mr. Daniels detained, who had broken into the club earlier that morning. Mr. Waters, the manager, caught Mr. Daniels inside of the premises claiming to be a technician, which proved to be false. Mr. Daniels was initially escorted out, but returned twice more throughout the day with other unidentified individuals. During these repeat intrusions, Mr. Daniels allegedly consumed alcohol that was stolen from the cellars. He also allegedly stole some tools from contractors who were working in the building. That's it for the factual basis from the state. I am aware of some previous criminal history that I'm sure you'll hear from pretrial. However, there has been two previous burglaries that that it's out of Florida. I've been speaking with Ms. Rios. She made me aware that Mr. Daniels has been in alcohol treatment and has been attending AA meetings and has a sponsor that has been very involved. And so that went into, I took that into account when recommending a sentence in this matter. And that's it from the state.
Okay, thank you. Ms. Jackson, good morning.
Good morning, Your Honor.
What can you share about Mr. Daniels, AKA Mr. Hubbard's criminal history?
Yes, Your Honor. I was just scrolling through it. Let me scroll up to the Georgia history so that I can give you a correct cycles. Apologize for the delay, Your Honor.
That's okay.
Here we go. Here he is coming up now. Okay. Now I can give you those cycles. There are 39 cycles. There's 36 out of Florida, 2 out of Tennessee, and 1 out of Georgia. The last arrest was March the 4th, 2025 out of Florida for a probation violation. He does appear to be on probation in Florida for burglary. That disposition date was January the 17th, 2025, and the term is for 2 years. He does have prior felony convictions. One in 2024 out of Florida, where they're all out of Florida, Your Honor, for larceny and possession of controlled substance. One in 2021 for burglary. An additional one in 2001 for possession of methamphetamine.
Do you say 21 or 01?
2021.
Okay, for methamphetamine.
Yes, Your Honor.
Okay.
There was one in 2020 for larceny, grand theft. And there was one in 2018 for grand theft and larceny. There was one in 2016 for grand theft. And he does have misdemeanor convictions. It's one in 2022 for loitering or prowling. One in 2016 for petty theft. One in 2013 for battery. Nothing in addition, Your Honor.
Thank you so much. Ms. Rios.
Yes, Your Honor. Mr. Daniels is 35 years old. He's originally from Florida. He has a 12-year-old daughter, and he was doing carpentry and tree work, landscaping work. He has been in AA. Actually, his sponsor's on the Zoom.
Is that Eric?
Yes.
Okay.
And he would like to speak. So the plan would be that he would go to PAD for right now to sign up for probation. So it's because he has to do that here. And then all his services and all the things that he can get help with is in Florida. So he would be going back to Florida. I believe Mr. Cook said that they could help with a bus ticket, and he's housing and services that would provide all that stuff in Florida.
Mr. Cook is Eric's last name?
Yes.
Okay, got it.
And I do understand his criminal history. He's had issues with alcohol, but he's been trying to address that. And the sponsor, said he has seen improvements. Yes, it's an ongoing struggle, but he, has been making strides to try to do better. So I ask that you accept the plea as negotiated. And I'm also asking for a behavioral incentive date of 3 years if he's been doing well, and to waive the fees for the first 6 months.
Mr. Hubbard.
Yes, Your Honor.
You shook your head a little bit when Ms. Jackson mentioned that you were on probation out of Florida. Do you think that you're not on probation in Florida, or you are on probation in Florida?
I am not, Your Honor. They dismissed the charge before I came up here. I was in a program court, and it was going to be reduced to a trespassing charge, and they totally dismissed the case before I came up here.
Okay.
Yes, Your Honor.
Ms. Simpson, you don't have any visibility into whether someone's on probation in another state? Okay. All right. Mr. Cook, was there anything you wanted to add on behalf of Mr. Hubbard's situation?
Yes, Your Honor. I've been in contact with a local community organization. They have bed space and availability at Baycare Behavioral Health Community Recovery Center. I've sponsored David on and off for the past 7 years, and I believe through the power of the fellowship I belong to, that if the willingness is there, improvements can be made. I'm an example of that. I was a criminal past and an inability to get sober, but when I hit a spot of desperation and enough willingness was there, I'm a valid member of my community now. I'm a son today, I'm a husband, I show up for work, I do the right thing. And I think if David's willing to take the steps necessary to get to that point, he can have that same future, but it's going to be on him and his degree of willingness to apply that in his life.
Okay, it is. I mean, it ultimately it's at his feet to get it right, but it's good to know that he's got a source of support. Tell me what you see Mr. Hubbard doing to embrace recovery and focus on sobriety, because he struggled over the last few years. You heard the criminal history I heard, and 24, 21, 24, 25. It's not something that was in the early 2000s. It's recent, and that says to me he's actively struggling.
Again, it kind of just falls down to the level of willingness that we're able to apply to this situation. But I've seen cases worse than David's recover, and I can say that with absolute certainty. It's if this is something I could bottle up and sell on a street corner and just force people to have and do and give, I would. It's going to be a matter of his willingness completely. We can lead him to water. We just can't make him drink. I'm hoping that this time is different. I'm hoping that, he kind of sees the blessings that are getting thrown in front of him this time and he grabs a hold of it. Unfortunately, just like my sobriety, it's not something that I have control of. It's something that I have to surrender to it, a power greater than myself or whatever you want to call it, and be willing to, work those steps and apply them in your life. And if he does that, I think he'll have great success. And if he doesn't, it'll probably be much the same.
Right. Okay. I very much appreciate you being here and being a resource available to Mr. Hubbard. I hope that he makes good use of that.
Thank you, Aaron.
All right. Mr. Hubbard, anything you want to add?
Yes, I want to say, first off, for going into the area and the building, I feel shameful for the things that led up and the scenario that I was in with it. I was using drugs too at the same time. So I would like, if it's okay, to write a letter to the victim for apologizing.
You could. It's been enough time. I don't know that the Opium nightclub still exists. And I don't know how we track that person down, but your heart's in the right place. So you're free to research that and do that. That would not be a violation of your sentence if you sent a letter. But I'm going to talk about your sentence a little bit later. Tell me, when you are out and stable, you intend to go back to Palm Harbor?
Yes, Your Honor. There is, that's what my sponsor wants me to do, and that's what I'm probably going to do.
Where's your daughter?
She is in Clearwater, Florida.
How far is Clearwater from Palm Harbor?
15 minutes away.
Okay.
So
what about work? Can you get work down there?
Yes, Your Honor.
Okay. Why is this an offered plea? If you feel bad about it and are admitting to it and you were in there and you were drinking their liquor, what part of it is an offered plea?
Well, the area was under construction, and I went in there. I got fearful. There was a protest going on, and I got involved in that, and I went there to hide. And I was homeless, and not in the best place. And I never intended to steal anything or anything like that, but it's just in my best interest for this scenario, because sitting in months on end, and wasting taxpayer dollars and running this through the muck, I'm willing to take the plea.
Okay.
And sitting in jail mentally is horrible.
I'm sure. All right. Do you have any questions about anything we've discussed?
No, Your Honor.
Do you have a weapons carry license?
No, Your Honor.
All right. Well, Mr. Hubbard, I find that there's a factual basis for your plea. I appreciate the Alford angle to it. That makes sense. But I'm going to accept the plea. I think the state could prove its case if it went to trial. I'm also mindful that it's from 4 years ago.
Yes, Your
almost. But I'm also mindful that in the intervening years, you've continued to struggle. Find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter the plea, and knowing means that you've understood the things we talked about. And if you didn't, you said, wait, tell me what you mean by that.
Yes, Your Honor.
You have any questions about anything else?
No, there was one thing I would like to state as well with the FTA in regards to respect to the court. And no term did I mean to avoid that court hearing. I honestly tried to stay in touch with the PD for 2 years.
It was a big passage of time. I'm not worked up about that.
Okay, yes, Your Honor.
Okay, and you clearly had things going on in your life. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Dilligard?
Yes.
And Mr. Hubbard, can we sign your name electronically to the indictment indicating your Alford plea?
Yes, Your Honor.
All right, I'm going to accept it as an Alford plea. Your sentence is going to be a little different, so I need you to listen up, because you have the right early on in this process to say, no, I'd rather go to trial on this. I want to withdraw my plea. So I'm going to sentence you to 4 years to serve 3 months with the balance suspended. So you got a little more time in custody, but when you get out, you are not on probation. You are going to have 2 special conditions to your suspended sentence. One is do not violate the laws of any state of the United States. And 2 is you stay out of the state of Georgia other than the South Georgia Judicial Circuit, which is a circuit that is right along the Florida border.
Yes, Your Honor.
So that means that for the next 4 years, you don't come to Fulton County or Cobb County or Clayton County. If for whatever reason you got to be in Georgia, you're in these counties that are right across the border from Florida over on the eastern side, the western side. I'm going to give you the names of those counties so there's no confusion, but you're going to be way south in Florida anyway.
Yes, Your Honor.
It is Baker, Calhoun, Decatur, that's a county, not the city, Grady, not the hospital, but the county,
Yes.
and Mitchell. Those 5 counties are the South Georgia Judicial Circuit. You can go there and that's okay. Anywhere else in Georgia, you're violating your suspended sentence. If for some reason, this is very unlikely, you get arrested in Atlanta 6 months from now, the state can move to revoke your suspended sentence. But it's not probation. You don't have to report to anyone. We don't have to worry about, wait, you're going to go to PAD, and how is supervision going to work in Florida? Given the age of this case, I think simply suspending it makes sense. But given your recent criminal history, I think that the 3 months rather than the 54 days makes sense. You'll get credit for all the time that you've been in. You're not going to get transferred into the state system. You're going to do a little bit more time right where you are. You'll be released, and then you're going to need to skedaddle out of Georgia, because other than those 5 counties way down south,
Yes.
because that's one of the conditions of your suspended sentence.
Yes, Your Honor. May I say about the time, the 3 months? There was 41 days that I was in jail on the original charge, and then while I was waiting on the warrant, the warrant was held. I have the warrant in my sock. I was held from March 5th until April 19th on that warrant.
Where?
In Pinellas County Jail, Your Honor.
Oh, meaning you were being extradited.
Yes, Your Honor.
Okay. If you can, I'm not going to make you take your sock off right here. That's okay. You're going to go back there. You can give it to Ms. Rios. You ought to get credit for all that time. And so we just need to see that warrant showing that you were in Florida. Again, please don't take your clothes off here in court. We just need to see that smelly paperwork. And if the documents when you were in, you get credit for that. And that goes towards the 3 months. Okay? So it's going to be even less time remaining. It's got to add up to 3 months. And so the 54 days you've already done, already credited to that 90. And then it sounds like there was another chunk of time also credited to those 3 months.
Yes, Your Honor.
And then once you're released, and the sheriff has the authority to release you early. It's his call because you're going to be staying in his jail.
Okay.
Once you're released, you need to leave Georgia except for those few counties.
Yes, Your Honor.
Any questions?
So they are able to give me gain time on that 3 months it's up to the sheriff?
Correct.
Okay. So as I know there's an issue with the name in the jail, they're gonna know
Don't know.
both.
The paperwork is going to say Daniels.
Okay.
It will say AKA Hubbard.
Okay.
But it'll all say Daniels.
Yes, Your Honor.
Okay.
And the warrant's right in the top of my
What
side.
did you say? It's in your side.
Deputy will help you get this.
Yeah.
Sergeant.
Sergeant.
The sergeant may, or you may. I mean, I'm going to let you guys work that out.
Uh-oh.
Come on.
It's a smart place to keep it if you don't have pockets.
Yes, sir. Make do with what we got.
The warrants.
Yeah, it's in here.
Open the door.
Okay. I took it.
That does seem like a Deputy Gordon assignment.
This is all my legal scratch on the back of it, but
You want to, what are those gloves? Sure.
Thank you, Ms. Hansberry.
Yeah.
Oh, yes. Oh, okay.
Look at that. He's got all the equipment.
If you want.
I'm good.
Do we, are we going to be here?
No, I just need to eyeball it. And then I'll let Ms. Nelson know it's credit from dates X to Y.
the bottom left shows the arrest date of the warrant.
Okay. Arrest date March 5th. So we'll give you credit from March 5th through today.
Yes, Your Honor. On top of the 51. So how many?
Well, the 53 includes the chunk since you got here.
Oh, okay. Yes, Your Honor.
Where's the waiver?
So just so we're clear on the record, and then you can be on your way, you will get credit for being in custody from June 8th, 2021 through July 18th, 2021. That's 41 days. And then from March 5th of this year through today. And that's going to add up to whatever adds up to, subtract that from 90, that's what remains for your max out date.
Yes, Your Honor.
Okay?
Thank you, Your Honor.
Yep.
God bless you, sir. I just want to say, united we stand, divided we fall, and I know we got to come together, and drugs hurt us.
All right, we got to send you up to Washington.
Thank you, Your Honor.
Bye.
Thank you, ma'am. God bless you. See you. Thank you.
Okay. So let's handle Mr. Hayes' situation. And if you don't mind letting Chief,
I gotta take you up.
okay, but we've got a bunch of folks who've been here for Mr. Hayes. So if you let Chief Clark know, I'm running a couple minutes, or that not okay?
Yeah, Mr. Rockwell had to go to 4L.
You kidding me?
I told you it was that shit, right? No, we need to see my ASAP. So.
All right, what else do we have? We'll do it. I have to meet with the number 2 person in the sheriff's office. I'm gonna go do that unless we've got some, we left Mr. Alford in a unhappy space. What does he want to do?
Alfred or Alexander?
Oh, did we not do anything with, that's sorry, Mr. Alexander.
Good. If we could bring him back out.
Yep.
He wants to resolve it. I want to alter my request.
Okay. All right, but Chief Clark's knows I'm not standing him up. Okay. All right, Ms. Minifield, sorry to make you bounce around. We're going to go back on the record in Mr. Alexander's case. That's position 6 on our inquiry calendar. It's 16 SC 147220. And Mr. Alexander, when we last spoke, we were talking about options. Your lawyer had initially, Ms. Wood, had asked for time served on the revocation, and Ms. Dilligard had said 4 years on the revocation. That's a big difference. I looked a little bit at the warrant, not the probation warrant, but the police warrant that got you locked up most recently, and let you know that I didn't think time served was going to be how this would shake out. And so I offered up, we can have an evidentiary hearing. That's not going to delay anything, given the size of revocation you're going to get if we reconvene in a month, whatever it is, we can do it that way. But I mostly wanted you and Ms. Wood to talk. Ms. Wood has been gone for a long time, meaning she's been talking to you for a long time, which is healthy. And I'm going to ask Ms. Wood now what Mr. Alexander's choice is.
Yes, Judge. So we're going to move forward with what we were doing, which was the non-negotiated stipulation. I failed the first time around to share some important information with the court. His wife is here in court. Ms. Quantisha is back there. I spoke with her. After speaking with him, she cleared up a couple of things for me, Judge. So he does still have that bond is not actually posted. The bonding company was waiting to see what happened here. So whatever happens, he'll still have to work through that.
Okay. And the family could save some money if it doesn't make sense to post bond right away.
Exactly.
Great.
He's 37, Judge. He has an address here. He lives with his wife and his 3 children, ages 8, 13, and 15. He has a 12th grade education. He does have his GED. He works at Gold Creek Chicken Plant in Gainesville. He thinks hopefully he can return to that job at some point. Judge, I'm asking for the court to consider revoking 18 months on this case and reinstating. And that is our request to the court, Judge.
Okay. Mr. Alexander, you live locally, but you hoof it all the way to Gainesville for work?
Yes, sir.
Oof, how long you been at the chicken plant?
7 months.
Okay. How'd you get the job?
Through a friend.
Okay. All right. Mr. Alexander, anything you want to add?
Yeah, I wasn't really trying to do no jail time. I was like, can I get a 24-month in-house program or something so I can still go to work or still be able to see my kids on a daily basis instead of going back to prison.
Okay. I understand that request. Ms. Dilligard, anything you want to add to what you shared?
Judge, I have nothing further to add at this time.
Okay. All right. Mr. Alexander, you were on probation. You get your warrant back for a cocaine and LSD and marijuana case. You actually were sentenced to 5 years in custody, followed by a bunch of probation. Eventually got out. And you are stipulating to the fact that in February of this year, you were arrested in a house that was the subject of a search warrant because police had made repeated undercover buys from that house. You were at the house when the buys were made. You were at the house when the warrant was served. You had documents with your name on it in the house. The house had a bunch of drugs, 2 guns, etc. You're not admitting to that. That doesn't mean you're being found guilty of those charges. I suspect that case will get indicted and you and a good lawyer will work through that. That's real inconsistent with one, being a parent, being a spouse, working at a chicken plant, etc. It's you getting mixed up in the kind of stuff that bit you pretty hard on the behind a few years earlier. And that's too bad. That's frustrating for a lot of people in your life. I am going to revoke 3 years of your probation, reinstate the balance. You will get credit for the time that you've been in Probation revocations are, of course, parolable. So you'll be eligible for a good time in that way. You also can see if there's a way that you can get the kind of treatment you say you're interested in while you are in custody. And finally, should this case get indicted, you may have already resolved this case by way of this revocation. Ms. Simpson, do you need anything else?
Judge, he will receive the required instruction.
Okay. All right. Thank you.
Thank you, Judge. We go that way.
So I should probably go meet with the chief and then come back here. We will not break for lunch until we deal with Mr. Hayes. So you guys can be at ease. If Ms. Rockwell comes back, grab her, don't let her leave. She is a busy woman. You've got a good lawyer working on behalf of your son, brother, however he's connected to you. But as you've seen, she's popular and gets pulled in lots of directions. I'm stuck here. She is off in different courtrooms. But when I get back, we'll talk about Mr. Hayes's case. We just took care of Mr. Alexander's. That leaves. So let me just circle back. So Elijah Jackson, what do we do with that? That's position 2. That says Ms. Wood. We held off on that?
Yeah, we held off. It's, I think the motion was set aside bench for.
Okay, and she was gonna, maybe you guys were working it. I think she had to talk with family and then she talked with you. So we'll circle back to that. Wilbur Alford?
That is conflict.
That's conflict. Okay. No lawyer yet for that person?
I need to look it up.
Oh, that's Mr. Gates's co-defendant. Okay. I can look it up. Nope. So, can your office, you've probably already done it once. Will you do it again, please? To start that process. Hopefully Ms. Cabrera gets the case.
That completes my application. Can I speak?
Almost. You don't have Brandon Ingram?
He's mine.
Okay. Yes, you may. Can you bring Mr. Alford to the door and then we'll be done with him? Not Alexander, Alford. Not Daniels. Not Hubbard. So Ms. Wood, I'm gonna go meet with Chief Clark. And when I come back, we're gonna handle Mr. Hayes' situation, Elijah Jackson, and Brandon Ingram.
Thank you, Judge.
If you don't mind sticking around.
Yes.
Thank you. Hey, Mr. Alford.
How you doing, sir?
I'm all right. We need to get you a lawyer. Your co-defendant on your case, Mr. Gates, already has the public defender's office. So that creates a conflict. You're entitled to your own independent lawyer. I didn't realize that when we brought you over here. And so we're working through the process of lining up a lawyer who can represent your interests. Probably need to bring you back next week to have the conversation about, hey, you had a bench warrant. Should we reinstate your warrant or what? I mean, reinstate your bond or what? But that requires a lawyer who is able to argue on your behalf. And that person's not here today because I didn't know we needed to get that person here. Okay?
Yes, sir. Can I say?
Sure. Don't talk about the facts of your case. You can say anything else you want.
Can I at least try to like fight on the street, try to give them a fair time?
So you can do both those things. But right now you're in custody because you missed a court date. And so the reason we're getting this lawyer appointed is so that he or she can say, hey, here's why Mr. Alford wasn't there. He was like, Gates wasn't there because he was in jail somewhere else. I don't know where you were, and we're not gonna talk about it right now. It could be you didn't get notice, you had moved, who knows? But we gotta appoint you that lawyer, so that that lawyer can convince me that I should take away the bench warrant. Because that's what's holding you right now, at least that, if not more things. If you get out, you're free to hire someone. So it's not a forever lawyer, but you need that lawyer to argue, this is why Mr. Alford should get his bond back. Okay?
I know it was, I know it was like locked up on the case, or made a bond on the case.
Let me look. Look at that. It's a direct indictment for you. That's all the more reason we better get a lawyer plugged into your case, because you currently have no bond. You never even had a bond hearing. We need to give you a bond hearing so that we can set a bond. Okay? So let me work on that. We'll get a lawyer appointed to represent you, and we'll either get you back here in person, or if we can do it sooner, we'll do it through that Zoom thing where you'd stay out at the jail. I'm gonna pick whichever date is fastest to get you back in front of me, okay? All right, sorry for the confusion.
So when I'm coming to court.
As soon as we get that lawyer, so I'm guessing next week.
Okay.
All right?
All right.
Ms. Dilligard, so we're taking a break. I don't know if there's even a grand jury warrant. You may want to look into that, because my guess is he didn't get notice. He probably didn't know he was indicted. I don't know what we would have sent where. There's nothing in the docket about that. So, but we'll get a lawyer appointed and then figure out what to do. All right, thank you, Ms. Rios, for your time. I'll see you tomorrow.
Yes.
And I gotta put the right shoes on. I can't.
Judge, what time are you coming back?
As quickly as I can convince Chief Clark to do what he ought to do.
I love that. Okay, thank you. Yeah. Can I go back? Are you going to break too? Just
No.
And
Text you.
I can try to search it.
Text me when you come back.
They don't have it scheduled.
Yeah,
Okay, we are back. Ms. Minifield, can you hear us?
Yes, Your Honor.
Great. Thanks for sitting tight while I had to go to that meeting. All right, we do not need to be on the record yet. Let's figure out what we're going to do. We have Mr. Hayes. How you doing, Mr. Hayes? I'm all right. I want to start by whatever we end up doing, know that I'm sorry for your family's loss. I've already talked with some of your family members, and I regret that you were not able to be there with your father at the very end, but we're going to talk a little bit about what might happen the next few days. Let me put all this into context procedurally. I signed a probation warrant. In your case, you have an old case. It's from 2011, but that judge gave you an infinite amount of probation. And this warrant that I signed alleges that in October of last year, you got arrested here in Fulton County for having a gun as a felon. You got picked up on that warrant. I guess you're being held in Cobb since you've got the orange jumpsuit on. You've got 2 years and about a month left on your probation. And you were originally on the calendar to work through, well, what are we going to do? Are you admitting to it? Are you challenging it? Do we have a hearing? Are we revoking? But something more important came up, and that's your father's situation. And so I'm fine today just talking about setting a bond that gets Mr. Hayes out for a few days, but then he goes back into custody until we work through this. But if you all are working through it, and you can convince me that it would be a time served revocation, we can do that. I don't know that that's necessarily the right fit. I don't think the state does either. But we can defer that. I'm okay putting that off as long as Mr. Hayes understands that his bond is of a limited duration. It's not you're out till the revocation. It's you're out to attend to important family matters, and then you turn yourself back in. And I'm happy to get on the record that you're adding 6, 7, 8 months to whatever revocation I give you if you don't turn yourself back in. But why don't you, Ms. Rockwell, let me know what kind of parameters Mr. Hayes's family is looking at here so he can plug in.
Judge, I do want to tell you one thing. Do you need me standing up? Can I sit down with him?
You're welcome to stay
thank
seated.
you
Our
so
court reporter needs to be able to hear you, so if you bend that microphone down, I know it makes awful staticky sounds when you move it, but that's fine right there.
Okay, so first I need the court to know that I'm trying to get to heaven, one pro bono probation case at a time. But I do also want the court to know, to be totally candid with the court, that there's one allegation listed on the petition. Madam Probation probably needs to hear this too. He has also been arrested in Clayton. That's not a joke. I mean, it's not anything that the probation won't eventually see.
Right, it's gonna catch up anyway. We might as well try to bring it all together.
Everything. Stand up for the victim in Clayton. Madam Prosecutors, talk to her.
Okay, meaning the arrest that Mr. Hayes had in Clayton County involved an allegation that he did something to this young lady.
Yeah.
Okay,
And she will tell you, or she can
I
tell
don't want to get into the substance of it. There was an arrest in Clayton, that's not on this warrant.
you. Okay.
Okay,
It will be,
okay,
and she'll come back.
okay.
And if I can give you the 60-second skinny, she shares an autistic son with
Your Honor, can you hear me?
All right. We lost audio for a minute. Ms. Minifield, are you able to hear us again?
Yes, now I am. Thank you.
Good, you're welcome. Sorry about that. Don't know what happened. Probably our calendar ended. So no more 60-second summaries. So there's a new Clayton situation not in there. Is there other things? Okay. Why don't I hear from Ms. Simpson?
Pending possession use paid.
Okay. So maybe we'll get a revised superseding, at least petition. I did. Okay. Got it. And does that have the Clayton and the Fayette in there as well? Okay. All right. We're not going to cover all that today. That just means the waters get muddier for Mr. Hayes, and it helps me understand why Ms. Dilligard was saying, yeah, it's probably not a time served situation.
And I know you don't want to hear that, Judge, but I'm so lucky to have the witness on that case.
The Fayette County case also?
Was that the Fayette case? That's a friend of his who has sickle cell, and his pain medication was left in the car. I wasn't there. I don't know.
Okay.
But he forgot it in the car.
Do you have a similar miracle about the gun in the?
No. Don't have that, Judge. I mean, we gotta eat that.
Okay.
But
You're saying it's not quite as bad as it may sound on paper with an arrest here, an arrest here, an arrest here.
I do want you to know that we got a little something to talk about. So I want to thank them. I couldn't draw like a crowd like this if I was giving away LIPO tickets.
Yep.
But you cannot have any contact with the police when you're on probation. So
This is true. More importantly, not any while you're out on this bond. What's the family situation? When you had Ms. Rockwell's been very good at giving me updates about what's happening. I think there's a viewing soon. Obviously, there's a celebration of life or a funeral. What are those dates?
Thursday, Friday, Saturday, stand-up matter, and I'll place her under oath if you need me.
She doesn't need to be under oath. How are you connected to Mr. Hayes? Oh, all right. So tell me the dates of things that you'd like Mr. Hayes to be at.
May 1st, we're having the family viewing, that's me and we have 8 children. And then the family viewing and family and friends is on Friday, and it's all at Gus Thornhill, and then on Saturday is the funeral service, which is at Gus Thornhill and Living Faith Ministry on Old Dixie.
Okay, and those are all in, I don't know where that is. Is that in Clayton County?
Yes, Clayton County.
Okay.
That's all, so it's Thursday, Friday, and Saturday.
All right. So if I set a bond that gets Mr. Hayes out now, and he has to return to Rice Street, would he return to Rice Street even though he's in Cobb?
Yes.
Okay. And now isn't, I don't want you to think now like you're leaving with your family. We'll get it processed. I'll have to work with my team on this, but gets Mr. Hayes out. But he has to turn himself, it would be a condition of his bond that he return to Rice Street at 9 a.m. on Monday morning. He would then be able to participate in all of the celebration of life and family viewing events, plus a bonus day of Sunday. Okay. Mr. Hayes, I think I technically can do this. I've never done it before, but I actually was talking to the chief deputy and he was intrigued by that because normally what happens is a judge says, you deputies have to go stand with this guy at the funeral, and when it's over, you take him back to the jail, which is a complete waste of deputy time, not because it's unimportant what you're doing, but that's not what deputies do. They're not supposed to provide security at a funeral with a guy in an orange jumpsuit and handcuffs. So I'm going to try this bond situation where you will be out, and there aren't conditions other than obey the law, and you turn yourself back in on Monday morning. If you don't turn yourself back in on Monday morning, know that, one, I will toll your probation. That means I stop that clock from running. So if you disappear and it takes us 2 years to find you, you're still going to have 2 years left of probation. And number two, I will revoke the balance of your probation, no matter what other witnesses Ms. Rockwell can get in here. You will have taken advantage of a real important situation to your family and disappeared on everyone. I'm not saying you're going to do that. I don't know you enough to say, hey, you're going to be tempted by it or not. I'm just laying out there in no uncertain terms. If you don't turn yourself back in on Monday, then when we do catch up with you, we'll have a hearing. I'll let you know what I'm doing. I'm revoking the balance of your probation, 2 years, 1 month, and a few days.
That's what's going on now.
No, that's what I'm doing if you do not turn yourself in on Monday. I don't know what I've already heard these two stories about how it was your son who was just sort of moving around and hurt his mom accidentally. She got frustrated with you. You got a friend who takes medication. So two of these situations may be easy to explain. You got it. Oh, I'm sorry, ma'am. You don't need to keep standing. Your gun thing may be harder to explain. I don't know what I'm going to do with that. I do know that if you don't go turn yourself back in on Monday, that I'll revoke everything when we catch up with you. Does that make sense? Do you have questions about that?
Once I turn myself in on Monday, how long will I still have to be incarcerated?
Well, at a minimum, until we get you back on a calendar, but I'll put you on the next available calendar. So a couple weeks-ish would be the shortest amount of time. Now, I could still, after we have the hearing, say, I'm going to revoke 6 months. I don't know what I'm going to do with that part. That's the unknown because we're not having that hearing today. Today was about how to get you out to be with your family while you're all grieving the loss. When I see you next, it's going to be what are the consequences of getting arrested, not once or twice, but 3 times while you were on probation. Okay?
Judge, can I ask just some questions? When you set this bond, is he gonna get turned around? Because I'm planning on going out of town.
I'm not sure what turned around
Is
means.
he gonna get turned around because of the other petitions?
I will make sure there are no holds. I'll take care of the holds. And his bond is going to have as its main condition, you turning yourself. This is an experiment. I've never done this before. If it works well, we'll try it again. If it doesn't work well, the main victim of that will be Mr. Hayes because I will revoke all his probation when I see him again.
And I can't suggest one thing.
Suggest whatever you want. I want it to work.
I understand. Only because this has happened before, and what Judge Lovett would do would be set a probation bond. And then he does a walk-in to the revocation. Because sometimes.
Yeah, we're not doing that.
I'm just saying, sometimes they might turn you away at the jail, and then Mr. Hayes thinks it's manna from heaven.
Got it. We're going to.
That happens. I'm not saying it's gonna happen. Let's also, can we try to figure out the next date for him, just so everybody's very clear, if that happens, he needs to come to the courtroom so they can figure out a way.
So what Mr. Hayes does, if on Monday he shows up at the jail and they're like, that's not how it works. You don't just walk into the jail and say, I need a room. If they turn him away, he calls his lawyer. And his lawyer lets me know that that was an issue. And then we fix it and give you, Ms. Rockwell, as the pro bono probation revocation lawyer, very clear instructions about what Mr. Hayes needs to do. He is doing nothing wrong if he shows up Monday morning and they say, nope, we don't know who you are. We're not processing you. You should go home. And then he should go home and call you right away. And you let me know, hey, McBurney, the experiment didn't work so well. That's not Mr. Hayes' fault. He is not making his situation worse. We'll fix it. And then it may be Tuesday morning, he tries again. We'll make it work eventually as long as Mr. Hayes is showing up when he's supposed to. But if it's Monday at lunchtime and I call the jail and say, hey, did a Hayes show up in the morning? The answer is no. Then all sorts of warrants hit the docket and all that kind of stuff.
Just because, Judge, I've seen it all. You know, I'm old.
I'm old also, and if it's not Mr. Hayes' fault, he's not getting sideways with me.
I understand. I wanted to say one other thing. In the event he cannot reach me, I want him to come to 8D.
Great.
And press the button that says Judge McBurney. And I think his people are going to get him here.
Okay, I'll be in court. You can walk on into court. And like, hey, what are you doing here? It's like, I tried to turn myself in, and then it's great. We can take you through that door instead. Okay, you'll manage that as you see fit. Ms. Dilligard.
My only other suggestion was possibly utilizing an ankle monitor would be the state's request, just in case, since Mr. Hayes does know that he possibly is facing time. We have concerns, and that an ankle monitor may.
That's a great idea. If it's a county-funded ankle monitor, it's costing him nothing as long as they have an ample supply so he could get it popped on today or tomorrow morning. When is the family viewing tomorrow? Okay, it's okay. So it's not till 4. So if for whatever reason this is proving complicated and your stepson is released at 10 tomorrow morning, that's plenty of time still. Okay. And you have good phone numbers to reach everyone to say, hey, I'm here, can you come pick me up? Okay. All right. Let's see if we can make this work. Last chance, Mr. Hayes. Any questions about anything?
Yes, do I get still credit from time served? I've been locked up.
Yes. Let me look.
He's been somewhere since February the 20th.
Yeah, you do. It's not that because you get out for a couple days, those days don't count. We keep track of all the time you've been in. So I'm making it up, but if I revoke 9 months and you've been in 3 months, you'll have 6 months that you still need to do.
So it's not 2 for 1?
Sometimes
it is. I'm not a 2 for 1 guy. And so if I think you should do 9 months, I don't say 18 months. If I think you should do 9 months, I say 9 months. And then I check a box on the form that says no 2 for 1. So if I think 3 months is the right answer, I'm going to say 3 months, not 6 months.
You know what, if he was to revoke anything, what it would be?
Nope, because I just haven't heard enough. But you'll be helping yourself by showing up on Monday morning. That'll show me that you're taking this all seriously. But today isn't the day to figure out, is it 1 month or 8 months or 1 day or 1 year? That's when Ms. Dilligard's going to say, here's what this is about. And Ms. Rockwell she doesn't have to confine herself to 60 seconds. She doesn't do that well. And she will be able to say, here's what all these things are about. And we'll talk about all 3 situations. Okay?
Yes, sir.
All right. You guys will make sure he's back on Monday? Each one of you. Good. Okay.
I just want to get my witnesses too, Judge. I never have witnesses that show up. No.
Well, this is family, and that also benefits Mr. Hayes. So you guys, enjoy is the wrong word, but have important family time over the next few days. Again, I'm sorry for your loss, but hopefully everyone being together lifts everyone up. And if Mr. Hayes navigates this correctly, he'll be there for those days as well. Okay? All right.
Thank you so much, Judge. Oh, he's going to set the bond.
Yeah, don't worry about it. It's not going to be a situation where you cannot make the bond. Okay? I have to talk with folks at the jail to understand technically how we're going to do this.
So is it a way that I'm not getting out tomorrow?
That would be a bad development. Ms. Rockwell will let me know. And so just to manage everyone's expectations, worst case scenario, then I go down to the jail on May 2 and we get you out on May 2. But my goal is to get you released. It probably won't be today because it's already afternoon. It would be tomorrow morning. But we have good relationships with people at the jail. And so they can help me understand what I need to put on pieces of paper so that when they get them, they don't say, what is this? Okay? Just stay in touch with your lawyer.
And it sounds like if there's other bench warrants, that's for the other case or the other whatever, that this will cover everything.
Unless there is a hold from another jurisdiction, just to manage everyone's expectation, I can take care of everything that is related to Fulton County. If Clayton County has a hold on Mr. Hayes, I can't do anything with that. My very limited authority is limited to Fulton County. So if there are we call them foreign holds. So if Fayette County doesn't have a hold on him and Clayton doesn't, then we're good to go. If they do, then you guys need to drive quickly to one of those places and say, could we please get this young man out for the funeral? But hopefully, it's just Fulton holds. And I'll get them out of the way, and then I'll put them right back in place on Monday.
Thank you so much, Judge. I appreciate it.
We'll see what happens. I'm intrigued. We'll see.
Say again? I don't think so. Does he have any holes?
We're gonna talk with the jail about it. We're gonna talk with the folks at the jail, and if we're told that there's a hole, we'll let Ms. Rockwell know, right? I'm not gonna like, you'll find out when he tries to get out. We'll let Ms. Rockwell know there's a hole from Clayton.
And what they do is they run the GCIC right before you walk out the door.
Well, we'll have them run it before then, so that I know whether this is gonna work. Okay?
Thank you so much, Judge.
Please go with the sergeant.
Judge, I'm sorry, Judge Dunaway.
That's all right.
It's these lawyers, it was just three defense attorneys and 2 prosecutor judges, that's all, and a judge.
We had plenty of other stuff to do.
Well, that's why I had to lay eyes on how many of y'all had in the peanut gallery.
That's right. Ms. Wood, what are we doing now?
Judge, it'll be very quick. Mr. Elijah Jackson, it's just gonna be a bench warrant set aside today. His mother is here.
No, we're good. Whenever you're ready, Sarge. Elijah Jackson. How much was yours for? How you, 450? Yeah. What? Why does he get more? Is there a good reason to set aside the bench warrant?
I think so.
Okay.
It'll be quick, Judge.
I'm not worried. We're good. Okay. Oh, no, the podium's still working, so we're okay. Okay, I'm not worried about that. We're on life support now because I think this was supposed to end at noon, this Zoom feed, and so I'm using like Band-Aids to hold it together. And we have another one starting at 1 for this civil case that's coming in. All right, you're Elijah Jackson?
Yes.
All right, you got someone in the back there for you.
Yes.
Mr. Jackson, you missed court. Let me find out what we've got here. 24. Let's see. You had your arraignment date in late February, missed it. I signed a warrant. You're back now, and Ms. Wood's going to tell me why I should set that warrant aside. And I'll hear from the prosecutor, see if she agrees or disagrees, and then I'll let you know what we're going to do. Looks like you've been in for about 40-something days now, and you were originally in for about 2 weeks, way back in 23 when you picked this up. So Ms. Wood, what happened?
Yes, Judge. So he missed that arraignment court date on February 27th. His mom, Kimberly, who's here present in court, she lost the housing that they had, and so they were living in her car, and that's why the notice did not get to him, and unfortunately, I didn't have a good number for him. I've since connected with her. She seems to be doing well and working. She's currently staying at a hotel, and so she is hoping that Elijah will get his bond reinstated so he can get out and actually get back to work so that he can help her pay bills so they can continue on the path that they're trying to go down, Judge, which is for a stable situation. He's 19 years old. He does have a 12th grade education. He was doing DoorDash work previously. And Judge, I think, are you still on an ankle monitor?
Yes.
Okay, he still got the ankle monitor on. So we were just asking that the bench warrant be set aside, that the bond be reinstated, since I do have good contact numbers for him now. And also, I would like to point out, he's a trustee at the jail. He's on the kitchen detail.
Okay. That was a lot, but it's helpful. Mr. Jackson, so you, back when this happened, were living with your mother?
Yes.
Okay, who else? Just the two of you or other people?
It was the 2 of us.
Okay. And were you at some point at an apartment or a house? Like, what was your address?
Apartment. We used to stay on 2591 Whitesmith Road.
All right, the address I have is 2054 Joseph E. Boone.
No, that's the old address. And then we moved to 2591 Whitesmith Road.
Okay, and then that's the place.
That's what we got.
You
We love.
you had to leave there, and for a little while we're in a car, and you're not, if the address we had for you was that Joseph E. Boone, it's not getting to you.
No.
Okay, got it. I think I understand that. How are we gonna get mail? I mean, you have good contact, at least for Mr. Jackson's mother, Ms. Wood. What kind of address are we gonna put in the system? Is it a long-term stay at the hotel?
Hopefully not, we just kind of got derailed for a second. We was trying to build like, to be approved to move somewhere.
Mhm.
The income and stuff.
Sure.
So it's gonna drop, with the income.
Okay.
It wasn't approved for the apartment, so we got to stack the money again.
Okay. And Ms. Wood may have said it, but you are working?
Yes.
What do you do?
I work at Starbucks at the airport, on customer seat.
Okay.
And I also work, I do the DoorDash as well.
Okay. And then your son helps support things by also doing DoorDash? Do you have two cars? Okay, so you might be at Starbucks and he's doing the DoorDash, or just,
We just doing, taking turns with the DoorDash.
got it, using the same car? Okay, all right. And for right now, it's an extended stay hotel, but your goal, understandably, is to get your own spot once financially that makes sense. Okay, all right. Ms. Dilligard, what are your thoughts about this situation?
Judge, state's concern is that there still doesn't seem to be a stable address for this defendant to get notice for future court hearings. So we have a concern in regards to that. However, we do understand that he did not receive notice for that court date and therefore did not willingly not come to court, but we do have a concern with him getting further notice.
Sure. That may be where the ankle monitor helps out. I'm looking at the bond. Gosh, you are in one of those categories of, you're coming up on year 2 with the ankle monitor. You keep it charged?
No.
Why not?
Because it just like, it fell off. Cause I guess I had it on so long, so it fell off by itself. Like when I was doing something, it fell off, so I glued it back together.
Where is it now?
It's still on my ankle.
Okay. So if we were to arrange for you to get a new one, as in like new and improved works better, you'd keep it charged?
Yes, I keep it charged.
Okay. I'm open to the idea of saying no more ankle monitor once you guys are able to get a stable address. But between now and then, I think I share the concern Ms. Dilligard has, which is not that you're necessarily going to disappear, but life is complicated and you and your mom may have to move around some. And the only way we have from the court side to tell you when your next court date is to mail something. Now, Ms. Wood will track you down through your mom as long as her cell phone number stays the same or whatever kind of email, whatever she's got. But we need a stable mailing address. Yes, ma'am.
If it's okay, I'll get a court my auntie address.
Okay, as in a place to mail things?
Yes, for him, I have to ask her though.
Okay.
What's going on?
Well, why don't we do this? Why don't you give that to Ms. Wood? If your auntie says, yes, I will accept mail for Elijah at that address. And if you tell her that, Ms. Wood can file a change of address form, which will then get into the system. That's the address where we'll send court notices. And then your auntie will just have to say, hey, I got one of these things for Elijah.
Is it P.O. Box, the P.O. Box acceptable? Or you need to have a physical address?
Wherever the mail goes. The address isn't so much where do I go to find Elijah as it is, I know if I mail it to this place, it will get to him.
Well, I can do the P.O. Box.
Okay.
And my number's on it too.
Okay.
I kind of like for me to handle a lot personal business, they step in with everything I feel needful, but
Sure. So do you have a P.O. box?
I just have to go get it.
Okay, well, when you do, get that to Ms. Wood, okay?
I guess I'll just kind of go with the residence.
I got you. And I don't want it to make it sound like there's court every other week. Your son may come back one more time and that's when he's working the case out. So we're not mailing things out all the time, but the obligation is on the defendant to be available and to let us know where to send things. So if it's Auntie or P.O. Box, I'm gonna let you two figure that out, but it won't work real well if he misses court again and the story is, we changed addresses. You now know that you gotta keep Ms. Wood posted, whatever your address is. This hotel, Auntie's house, P.O. Box. That way Ms. Wood can keep us posted, okay?
Okay.
All right. So I will reinstate your bond, and I'm going to ask you to. Your ankle monitor is so old, it may still be an A&A ankle monitoring. I'm gonna work with our ankle monitor person. You have a good way to reach Mr. Jackson?
Yes.
Okay. You may get an instruction from your lawyer to go to the ankle monitoring place to get a new one.
Okay.
So that you don't have to use staples to keep it on your leg.
Okay. Quick question. How long do I have to have the ankle monitor?
Until you resolve the case, or your mom convinces me that this is a place where you're gonna be staying. She got a year's lease, whatever it is. And I don't wanna rush her on that. I'm sure she is anxious to get you guys your own spot. But until then, ankle monitor on, because we need to make sure we can track you down. Okay? All right. I think that's it. Ms. Dilligard, anything else?
Nothing further, Judge.
All right.
All right, you're gonna go.
Oh, one before you go. How far did we get? You just did a waiver, so we'll do a scheduling order.
Yes.
Okay, great.
Yes.
Just keep your phone on and charge. So, like, when I go to. You said you'll do it, oh, yeah, sure. Okay, I appreciate it.
You're welcome. Have a nice day. Should we have them through, please?
Yes, because what's next is a civil case, but. I'll go call right now and then we'll take the plea. Let me check one thing I'm getting asked about.
Ingram. Yeah. Brandon Ingram.
And that's the plea?
Yes.
Okay. All right, call him on his cell or his desk?
You just said call.
Okay.
Now, the number.
What?
Yeah, the number 4?
Yeah.
Okay.
I sent you his Ingram's information, right? Okay.
All right.
Amazing. Thank you.
Are you gonna need this?
I think so. Well, will he have reporting instructions?
Is it?
Ingram, it's gonna be a felony plea.
Oh, yeah.
Yeah, okay. Oh, does he want to sit down?
Okay, I want to sit down. Okay, you sit down, right? Just come back. Give him up, I don't sit.
Yeah, no, Charlie.
No.
That's why he's so cranky.
Hey, I did this other man.
We can sit here. Okay. Nothing's changed. So what we'll do is we'll move over back there, and then, like I said, the state's gonna ask for a little bit more time than we are. We're gonna ask for what we're asking for. And then the judge will make a decision. If he says something like that you don't want to take, you can withdraw it. It's not a big deal. Okay? All right, cool.
Hey, but you good for Friday? He said, well, thank you, straight.
That's what, so
Hey,
we're asking for
yeah.
3 years probation, okay, and credit for the time that you've done. And then the state's probably gonna ask for a little more time, and then the judge will make a decision, and if he doesn't give us what we're asking for, we can say, whoa, judge, we wanna take it back, okay? But I'm pretty confident. I think he's probably gonna give us close to what we're asking for, okay?
Oh, yeah. Yeah, I gotta remind you.
Oh.
Last time I was 14, I had blood complications.
So we don't go home today.
I know.
I about church.
Okay, so.
Love.
I'm gonna write down. Do you, Ms. Simpson, do you give him a piece of paper with the reporting instructions and stuff? Okay, perfect. So after this is over with, she'll give you a piece of paper to make sure that you know when you're supposed to report and where you're supposed to report to. And I've already given her Lizzie's and your cousin's address, so that's where probation is gonna be looking for you at, okay? All right, so if you move or anything, you gotta update it with probation, okay?
I don't want to stand for a whole hour.
He got on the stand?
No, he ain't gonna stand.
Oh.
Crime scene, look like a straight house, straight talk out like this.
Are you in Schwal? What part are you in?
Yeah, it was. I
Oh,
was like this.
So, hey, what is it looking like? We got him. What are they doing?
Doing the null pros for Frazier.
Bruh.
praise the Lord.
You talking about
Yes, oh my
homeboy
God, I
downstairs?
was so annoyed with
Oh,
him
he comes up,
yesterday,
yes,
so he
I
was
do.
supposed to be
You
with
gonna
my
give him,
investigator
he
yesterday
can come
morning,
up.
and then she was like in the field, so they never connected, so
They got a
then
fingerprint.
you reached out to me, so I was like, let me just call him.
Yeah.
So I called him and he was like,
Yeah.
oh, I'm gonna head to the office right now and I'll leave
What
it
you got
or
going on?
whatever, I was
What you
like,
got?
fine,
You
he's
got
like, I was at the jail, like,
I ain't
whatever.
got
Yeah.
no chicken.
He called me at like 4:30. And he was like, I'm headed to your office now. I'm like, what is insane? Like, literally, no one's gonna be there. It's gonna take you like an hour and a half to get there.
Yeah.
So then he like didn't want to bring it to court today. I'm like, what are you scared of? Like, so that's why I like met him in the hallway.
Yeah, the judge asked about it like when we were leaving
Okay.
yesterday, but I let him know. I think her investigator is getting with him.
Okay, perfect.
You just let him know that you got it.
Thank you.
It's no pros.
I'm so hungry.
I just got a transfer order for Ethan Brown.
I saw that too.
What is that? I don't even.
So his cases are going to Ingram. Yeah, best ever. Yes.
All of them.
Yep.
The whole crew.
The whole thing.
Yes.
Wait a minute, don't get too excited. They rejected it. I'm trying to work on it.
What? Why'd they reject it?
It might be the way I wrote up the order, but they're fussing about the related cases, so I'm redoing it. We'll see. Cross your fingers.
Oh my God. You do like a rain dance. That's not about you.
That's
Ethan Brown. He's got a bunch of cases.
Yeah.
Mm-hmm. I'm sorry?
I had a doctor's appointment on the 27th. I was telling the jail about it. But they never told me about my heart. I got to test the heart thing.
Do you take medication for that?
Yeah.
Do you get it at the gym?
Yeah, I take, I'm getting blood.
Okay. Do you take it in the morning or at night?
And,
Okay. And when you're out on the outside, where do you get your medication from?
great.
Grady? Okay.
Yeah, I have a, it's my alpha rating, but I had a, appointment to go to see the heart specialist,
Mhm.
but I wrote mail and told me they didn't take me.
Okay, so that's even more reason to hopefully get you out of here, okay? Yeah, so, do you have you don't have an upcoming appointment or anything?
Yeah, you just passed on 27.
Oh, you missed it.
Yeah, I gotta make a new appointment.
Okay. And is Lizzie, your cousin, gonna help you make that appointment?
Yeah.
Okay,
Yeah, my girl, she pretty good.
Okay.
She been around with me a long time. We
Okay.
got 2 kids together, 4 grandchildren.
oh, nice. Do you have a vehicle? How do you get around town?
Yeah, we got a couple.
Okay, and she helps you get to doctor's appointments?
Yeah.
Okay. How old did you tell me you are?
61.
Okay.
I'm born 8863.
What day?
8863.
Okay.
I said, I know I was doing the right thing by turning myself in. But
How did you know you had a warrant?
when we moved, you know how we do the mail transfer?
Oh, okay.
And that's how I got mixed up.
Okay. You just went to Rice Street and said, I have a warrant?
No, I came to, I walked from Campbellton to Cascade at the precinct and turned myself in there.
Is that a long way to walk?
Yeah.
Oh my
Where I
goodness.
stay at now.
Okay.
I stay, almost Greenbrier.
Okay.
I was just tired trying to get everything behind me.
I'm sure you are. I think this is your only open case right here.
That.
Yeah, you can say it there. Yeah, you're good.
Hopefully our Zoom is still there. Yes. All right. Are you Mr. Ingram?
Yes, sir.
Ms. Minifield, are you ready for one more plea?
Yes, Your Honor.
Great. Thank you for your patience. This is position 3 on our add-on calendar, State versus Branyon Ingram. Mr. Ingram is here in court with his lawyer, Ms. Wood. We have Ms. Dilligard here as the prosecutor. And Mr. Ingram, I'm told that you're ready to go forward with a plea.
Yes, sir.
Okay, Ms. Dilligard is going to put you under oath in just a moment. Once you're under oath, she's going to ask you some questions. You need to answer those as best you can, and you need to let me know or Ms. Wood know if you have any questions of your own. Will you do that?
Yes, sir.
Okay, Ms. Dilligard, when you're ready.
Before we get started, just for Ms. Nelson's purposes, it's gonna function as a non-negotiated plea.
A non-negotiated plea. Thank you for Ms. Nelson's purposes.
Mr. Ingram, can you please raise your right hand to the best of your ability? Do you swear or affirm that the testimony that you'll give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true and correct legal name for the record.
What's his name?
What's your name?
Oh, okay. My name is Branyon Ingram.
Okay, Mr. Ingram, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you did not take today?
I'm on blood thinners for congestive heart failure
Did you take the blood thinners today?
this morning.
When you take the blood thinners, do they make you sleepy or woozy?
They stopped me from getting blood clot.
Well, that's good. I want that to happen, but they don't make you fuzzy or unclear.
No, no, sir.
Okay.
Mr. Ingram, how old are you and how far have you gone in school?
I'm 61 years old. I graduated.
Graduated high school?
Yes, sir.
Where'd you go to high school?
Brown High School
Where's that?
in Southwest Atlanta.
Mr. Ingram, Do you understand that you've been charged with the following offense? It's 1 count of entering auto.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state's required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances relating to the charge?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects in the indictment for purposes of the plea?
We do.
Mr. Ingram, do you remember having been arrested for these charges?
Yes, ma'am.
Has your attorney advised you of the minimum maximum sentence for the charge which you're pleading guilty to today? For entering auto, it's the minimum is 1 year, the maximum being 5 years.
Yes, ma'am.
Do you understand that your pleading guilty today is called a non-negotiated plea and that the state may recommend a sentence to the court even without you having agreed to it in advance?
Yes, ma'am.
Are you aware that the state's offer in this case is 5 years to serve 9 months? With the special conditions that you receive a drug and alcohol evaluation?
Yes, ma'am.
Is the balance probated?
Sorry, yes, Judge, balance probated.
Okay.
Have you discussed the offer with your attorney?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on this charge?
Yes, ma'am.
Do you understand that if you enter a non-negotiated plea, you do have the right to withdraw your plea once the court enters his sentence?
Yes, ma'am.
Do you understand that a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the presumption of innocence, the right to the assistance of counsel, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Mr. Ingram, how do you plead to 1 count of entering auto and indictment number 23 SC 189144?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on March 14th of 2022, officers were dispatched to a car regarding a larceny from a vehicle at 874 Westmont Road Southwest in Fulton County, Georgia. Upon arrival, officers made contact with the witness, who stated that when he was backing out of his driveway to go to work, he noticed this defendant entering into the victim's car, Miss Amy Cobb. The witness, Mr. Turner, stated that he then saw Mr. Ingram run down the street. He was able to get out and grab him and detain him until officers arrived. Officers were able to recover the backpack and that was taken from the victim's car. Mr. Ingram advised that his plans were to sell the backpack and jacket for money. Judge, the recommendation is based off a review of this defendant's criminal history. This will be his ninth felony conviction. He has two previous entering autos. His last one that I see is back in 2016, where he got a sentence of 5 to serve 2. This defendant also has picked up 2 new cases while on bond on this case. They both looked like, one was from August of 2024, the other, which was an entering auto, and then there's another case from December of 2024, which is a theft by receiving. They're both in unindicted status, but were, I believe, dismissed at the prelim due to
No officer?
Yes, Judge.
Okay.
That is everything from the state.
Okay. So the repeat offender notice lists 5 convictions. There's a recidivist notice. I'll ask you about that a little bit later. It lists 3 convictions, 2 of which are on the repeat offender, but you're saying you had a total of 8 felony convictions you found for Mr. Ingram?
Yeah, I see 1, 2, 3, 4, 5.
I'm not doubting you. It's just I usually just look at that repeat offender transfer thing and it lists, and 5 is plenty. I'm not saying, hey, let's try to add to the mix. A lot of them are super, super old. They're A's and Z's. But more to the point about what's been going on, there was an arrest in August and September of just last year for what this case is about.
Yes, Judge.
Mr. Ingram struggling. Okay, thank you. Ms. Jackson, thank you for sticking around. How many cycles do you have for Mr. Ingram?
29.
And the most recent?
The most recent arrest, Your Honor,
Yes, ma'am.
January the 1st, 2025, with the City of Atlanta Police Department for theft by receiving stolen property and 2 counts of financial transaction card theft. Those charges were dismissed on January the 24th, 2025.
Okay. All right. Thank you so much. And thank you for supporting us today.
Yes, sir.
Ms. Wood.
Thank you, Judge. So he's actually here today on the calendar for the bench warrant. He missed court on March the 4th this year, and he really wanted me to share with the court that he was in the process of moving. And so once he got the address change form completed with the post office, he received notice. He actually walked a great length to get to a precinct to turn himself in. So he wanted the court to know that he was not intentionally missing court.
Okay.
Judge, he's been in collectively since 2022. If you add in all the time that he's done for the new cases that were dismissed, 146 days. I'm asking the court to consider a sentence of 3 years probation to serve 90 days in custody. That would actually take care of the initial 75 days that he did on this arrest, as well as the 20 or so days that he's done currently. So, Judge, he's got a stable place to live. I've shared that with probation. I confirmed it with his partner as well as his cousin. He's got 2 grown children, 4 grandchildren. He does have some health issues. Judge, we think the evaluation and any treatment as recommended is appropriate for this case. And that's it, Judge. I think hopefully he's learned his lesson. This was a 2022 case. And now that he's got a stable situation to return to, he's just eager to get out and get back to his life, Judge.
Got it. Okay. Mr. Ingram, 4 grandkids. That's exciting. Are they local?
Yes, I just got back in their life, you know.
Okay. How old is your oldest grandkid?
My oldest grandkid is 8.
And the youngest?
He's 1.
Okay, you got a good range there. And that means your 2 kids are local, I guess, if all the grandkids are local. Ms. Wood says you have a stable place to stay when you do get out. Is that a friend or a family member?
Family member and my wife. Well,
Okay.
we've been together since '93.
Okay. You've got the person you called your wife. You two have been an item for.
I got 2 kids by her.
Okay, those would be the 2 kids who got you the 4 grandkids.
Right.
Okay, and where is she? She's in that household where you would go stay?
Yes, sir.
Okay. Mr. Ingram, in looking at how you have been arrested here and there and the kinds of things, it says to me that either you have trouble finding work, or you've got an addiction of some sort, and maybe because you've got an addiction, you have trouble finding work. Is that a fair assessment?
I had an addiction, but I got rid of that because I kept staying in trouble and I didn't want to lose my grandkids no more.
Sure. What was the addiction to?
It was cocaine.
All right. When you say you got rid of it, that doesn't, it's not kind of thing you can throw in the garbage can. How'd you get rid of it?
I just stopped.
Okay.
I didn't want to lose my life no more because I really got heart trouble and that's going to kill me if I keep on doing it.
You betcha. I heard about from Ms. Dilligard and then from Ms. Jackson, arrests in August and September, maybe one in January, that seemed like it's kind of the same stuff. Was that still when you were using and you got rid of your addiction just like a few weeks ago?
On that, it was a misunderstanding on the 2 cases, right? And the credit card, I got the card from a friend.
Okay, I didn't mean to ask you about the facts of the case. It's just you're telling me that those cases aren't related to your addiction.
No.
Okay, all right, got it. Anything you want to add?
Yes, Your Honor, I just want to apologize to the court by not making my court date.
I'm all right with that. I don't think it was intentional.
No, it wasn't. And I
Okay.
just wanted to ask that if you please give me my life back, you will never see me no more. I don't want to go to jail. I'm 61 years old with a bad heart.
Okay.
I just want to go back to my family, live the rest that I got.
I hear you, and I hope you are sincere about that.
I am sincere.
But it's your life to take back, not for me to give back. You were going to get out. You're not getting out today. You're not getting out tomorrow. But when you get out, you are the one who will decide, hey, am I going to do the kinds of things Mr. Ingram did in 2015 and 2020 and this, or am I going to be there for my kids and grandkids and my wife?
Yes.
So you're old enough now to make those decisions all by yourself. Mr. Ingram, I find there's a factual basis for your plea. This happened a long time ago, but you've not your first time that you got mixed up in something like this. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means you've understood the things we talked about. Do you agree with both those?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if you have a little problem, maybe you miss a meeting or heaven forbid you test positive for something, you and probation will sort that out. You don't have to come see me. But if you get arrested for anything, bad credit card, entering auto, anything like that, that comes back to me. And that will be a sign, Mr. Ingram, that you are not ready to take your life back.
You will never see me no more.
Well, I hope I see you walking down the street. I just don't want to see you in here, okay? Ms. Dilligard, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Wood?
Yes, Judge.
Mr. Ingram, is it okay if we electronically sign the indictment indicating your guilty plea?
Yes, sir.
Yes, I'll do that. Doesn't sound like there's restitution.
No, Judge, the victim got her.
She got her backpack back. Back in 2022, what would you have sold the backpack and the jacket for?
I don't even know, Judge.
No, I don't mean the money amount, like, hey, I get $25 for that jacket, but was that back when you'd sell it so you could buy dope or?
To pay bills.
Pay bills, okay.
I didn't do it for drugs.
Well, you're gonna have to pay bills when you get out. What's gonna be different?
I'm working on my disability and my Social Security. I have worked, half my life.
Okay, good. You should pursue that. Ms. Dilligard, a colleague of yours filed a recidivist notice in this case. Are you withdrawing that for purposes of sentencing?
Yes, Judge.
All right. Mr. Ingram, I am going to sentence you to 4 years to serve 6 months with a balance on probation. You will get credit for some of the time you served. You're not going to get credit if you got arrested in August and were in for a little bit. That's not this case, so you're not going to get credit. You'll get credit for that big chunk of time you served back in 2022, And then more recently, since you turned yourself in, we'll add those together. You'll get credit for that. And then you'll be on probation for a while. The one special condition of your probation is that you're going to meet with a doctor or a counselor and have a drug and alcohol abuse evaluation. And if that person recommends any treatment, going to meetings or this or that, that's going to be part of your probation, is getting that treatment. It may be they say that's not an issue for Mr. Ingram anymore, but if they recommend treatment, that treatment is part of your probation.
Yes, sir.
Any questions?
No, sir.
Okay. Ms. Simpson, I meant to ask you, Mr. Ingram is not on probation anywhere in Georgia right now. Okay, all right. Ms. Simpson needs to give you some reporting instructions for when you do get out. You're going to need to report to probation, okay?
Yes, sir.
All right. You want to go talk to him there or talk to him here? Okay.
It'll just be to report within 48 hours.
Right, so you'll need to report to probation within 48 hours of being released, but Ms. Simpson may want to get a little bit of address information from you now, okay?
Yes, sir.
All right. Thank you, Ms. Dilligard. Thank you, Ms. Wood.
Thank you, Judge.
Thank you, Judge.
I'll bring us back there too, okay?
Ms. Minifield, thank you for your help today.
That is that.
Before you go.
I'm coming back there, yes.
Thank you, Your Honor. It's a pleasure. You have a good day. Rest
You
of your day.
too. All right. All right, Ms. Niles, if you are on, I'm going to end this Zoom and you can fire up the next one.
Judge, we did